Yes. 1 minute. Inclusions, please hand over the slips.
Contempt application.
Inclusion, hand over the slips. Please pass on the slips from behind. Yes.
My lord.
Hmm. Yes.
My lord, item number 1107. The petitioner purchased a immovable property. 1107.
Yes.
Petitioner purchased a immovable property from bank in the year 2023. Upon
What you want? What you want?
upgrade, my lord.
Item.
1107.
Give notice to the other side and follow the list, please.
Grateful.
1220. Yes. Slips not required.
My lord.
1360. The upgradation is needed for the admission of the girl will not be done within August, because FD which has been kept for the girls' education, that has not be cannot be encashed by the bank, is not leaving that FD.
You've mentioned. Let us see. Yes.
My lord, item is 1011 of monthly estimate.
1011. Please move behind so that
One more.
persons from the back can come.
1334.
No, sorry, one only.
Lordship.
1445.
1445.
694, Lordship.
694.
Grateful.
My lord.
My Lord, 1765.
1765.
My lord, once.
No,
Alert.
Prakun.
Once.
422, yes.
May I have your
Lord,
lordship
17
sign, my lord?
1240.
My lord, 178.
1 minute. Yes. 961.
My lord, may I have your lordship's kind leave to mention, my lord, if your lordship can hear me?
727. My Lord, 1024 and 25.
Please don't shout. I am trying to accommodate as much as possible.
1024 and 25.
1024, 25. One at a time. I am taking two, but then it will be one.
My lord, 1781 and 1782. Both are
One.
analogous, my lord. Join, tag together.
788.
8 and 1782.
955. Lordship,
Please keep the doors slightly vacant so that the members can move out.
Lordship, 955.
Yes.
May I get your lordship kind leave, lordship, to move on a bit urgent.
1 minute.
My lord, my prayer is for inclusion and urgent listing, my lord.
Inclusion.
And urgent listing, my lord.
Inclusion. Hand over the slip. Do not mention, please.
My lord,
Hand over the slip.
passed by the division bench, my lord, giving me.
Hand over the slip, I'll see.
766.
766. Yes.
1533 and 1534.
Are they analogous? 1533, 1534. Yes. 1397. 915. Only one. 1779. Yes. 1103. Yes, please go. Yes. Yes. 1349. 922. 1128. Not in this way. Please maintain the decorum. 703 has been recorded.
523.
523. 523. Who is shouting from behind? Let it remain. 523.
523.
দরজাটা একটু খালি করতে বলুন তো যাতে
Lordship,
দরজাটা একটু খালি করে দিতে বলুন।
lordship,
I have taken your mentioning. Why are you mentioning again?
There's another matter.
No, please wait. Rationing has to be done. You can see so many are there.
Not for
Cannot be
upgrade.
helped.
Lordship 824.
All right. 1756.
1756 and 1757. Analogous matter.
My lord, 11 identical matter, my lord.
Wait.
My lord, same identical matter.
If you are over, please leave, sir. You see, just see what is happening behind. Please leave.
Lordship, this is a restoration matter. That's all.
You have mentioned one. You cannot do so many at the same time. Yes. 404. Yes. 1236. 1341. Yes.
874.
874. 16. Do something. What to do? Please go out.
My lord, may I have your lordship's kind leave to mention one
724.
matter?
Please leave. There is a lady behind you. Please see.
My lord, 9 to
Somebody is there in front of you. Please wait. In case the lady members have any problems, I'll take mentioning tomorrow for the lady members. You all may leave. If you can move out. The lady members, if you all feel difficult, I will take mentioning for only the lady members tomorrow. You all may leave. Yes, please.
Lordship 824.
933.
928, Lordship.
All right.
Lordship 824.
Please leave. 85.
1347.
Please leave. It's not required. Please leave. Yes.
1376.
No, madam. One at a time.
1347.
1125.
All right. Leave.
Lordship 824.
Just now you mentioned. I do not know monetary or what. You can. You mentioned one. Please maintain rationing. Please do. Yes.
1347.
1554.
My lord. My lord, kindly.
That is not the way. There are members standing in front. Don't shout. Yes, madam. 968. 481. 893. All right, you all move out. 893. 1211.
1347.
Yes. 576. Those who are over, please move out. Please move out, those who are over. 1168. 768. 582. Yes.
923, 1287, 1288. Analogous matter.
First one. 923. 1287. 1288.
My lord, mine also. My lord, mine also, my lord.
824.
My lord.
Please move out.
1379. 1400. Analogous matter. 1379.
1379.
1400.
00. Yes.
My lord.
My lord, 1377. 1316.
All right. 1316.
465.
You mentioned just now? No, one at a time. Please go out. Please go out.
My lord, 165. 165.
165, yes.
465.
465.
1377.
Shouting from then. You are seeing I'm doing. What is it?
1347.
Yes, move. 1347.
1377 euro.
992.
992.
1377.
Please move out. Let her go out, please. There are ladies standing behind. Please maintain decorum of the court.
My lord, 1386.
1386.
My lord.
My lord,
1612.
You mentioned just now, whatever, inclusion, what is it?
1612.
1612.
New motion urgent listing.
Crushed. Please let her move out.
New motion urgent listing.
My lord,
Give.
Triple
118.
My lord, 1377.
721. 13. 17842.
My lord,
Please leave. Yes, madam. Is it there in the list? Nothing.
may I have your lordship's kind in-
my lord, 1647 and 1648.
তুমি চলে এসো।
My lord, 1847.
1847.
My lord, 727.
All matters that are upgraded, please serve notice upon the other side. Otherwise, the matters will not be taken up and it will be put back in the same position in the combined list.
My lord, 873.
873,
1647, 1648. Analogous matter.
164,
1648.
1648,
My lord, may I
My lord, 722.
722,
my lord, may I have
465. 667 item for different techniques.
667,
67.
667,
1371.
611. Yes.
My lord,
Move out. Please move out. Those who are over, please move out. It's not required.
My lord, 1104.
My lord, 1095.
1095.
38, my lord. 438.
Just now you mentioned.
Not 1460.
No, one. 1 I have taken. I cannot see. 1460. All right. 655.
1506.
My lord, 430.
My lord,
430.
430.
1506.
1 minute. Please let these those who are over to go out.
1506.
1506. 905.
my lord 1016 10
491.
my 1465 my lord 1016
Yes. You are over. Please go out.
my lord 1016 may I have your lordship's attention
434.
1371, my lord.
1309.
my lord 1016
Oh, those who are over, please move out.
My lord, 1371.
1319.
my lord 1016
Just now you mentioned one.
my lord 1016 only
1016. Move out. Move out. 1631.
My lord, 1371. Sir,
1631.
item number 1465 এবারে বলে দাও
1465.
821, your lordship. 821.
821.
Paying for upgradation, the contempt application.
number
Application is not there in the list. Why are you mentioning today?
371.
Contempt application I take up every Thursdays, and whenever there is an upgradation mentioning, I take it up immediately. Why are you mentioning? Yes, please. What is your you're over?
No, my lord.
What
My
is
lord,
it?
My matters are 11 identical matters, my
All
lord.
right, give the list.
My lord.
What are these matters about?
My lord, only the disbursement of the due bill amount, my lord.
Payment of dues?
My lord.
Very well, give the slip.
my lord may I have
Item number 934 to 930.
Give the slip. And one thing, make sure that your other side is there.
Yes, my lord.
Ex
Absolutely.
parte orders will not be
No, my lord,
passed.
no, my lord. I will give the notice, my lord. I will give the notice.
One matter, 954. My lord.
954.
My lord, 1371.
my lord may I have your
371.
my lord may I have your lordship's attention regarding 1714 and 1715 my lord I have a prayer to your lordship because these two matters are specially assigned matter to your lordship is a short sheet matter but now your lordship has shifted it in the hearing list so my lord, it will be difficult my prayer is this if your lordship kindly take up this matter for 1 hour only within any day
Well,
at week
I'll keep it in mind. Yes, please. 678. Slip is not required. Slip is not
no, the
required.
notice is there my lord
Keep the notice with you when it is upgraded or when hearing is taken up, then you'll be requiring that notice if your other side is not there. 6, 7, 8.
My lord,
Yes, madam.
1.04.
Just now you mentioned one? 795?
Ma'am, can I mention?
1254. While those who are over, please leave.
This is for inclusion.
Just now you mentioned one? No?
And over the inclusion slip, ma'am. I didn't mention it.
Yes?
1749.
1749.
Yes, ma'am.
1098.
775 will also.
75. 1093.
1013.
1285.
1285.
Lordship 633. Lordship 6.
1 minute. 990.
Lordship 13.
Lordship 633.
633.
And another is for release, Lordship. For release.
633 for release.
No, not 633. 1618 for release.
Why?
Lordship, it's pertaining to the determination of Honorable Justice Kaushik Chandra, Lordship.
1.
Electricity. 1618.
16. Nirmal Babu. Nirmal Babu, 1618 released for want of determination.
Lordship 1303.
Give your name, please.
Lordship 1303.
Electricity matter? What matter?
Electricity, Lordship.
Electricity matter.
Connection.
Let it be released.
My lord.
May I seek your ladyship's kind leave?
1090. Please do not
My
make
lord.
this mistakes because it becomes very difficult.
Lordship 1303.
Very well.
My lord. Lordship.
481, your lordship.
My lord.
Where is the slip? Hand it over just.
My lord. 1303. For us to mention it after the exchange of completion of affidavit.
You have mentioned it.
My
The
lord.
work is over.
1078.
May I have your
1078.
lordship's kind leave to mention
sorry,
item number
sorry.
481, your lordship.
1087.
Please take care of the number and then mention. Otherwise, everything will go topsy-turvy.
May I have your lordship's
1087.
kind leave to mention 481, your lordship.
775 will also.
It's only for
May I
release of
seek your
shares,
ladyship?
Just now you
lordship.
mentioned.
Share
I
money,
can
but-
see 775 recorded over here.
I didn't know you wrote it down.
Please don't make things difficult for yourself.
This is for inclusion.
My lord, one.
This is for inclusion, my lord.
Hand over the slip, please.
A very urgent writ petition I mentioned.
May I have your
in
lordship's
last
kind
week,
leave to
lordship
mention
directed me
481,
to
your
come
lordship.
today and mention
Give the number, please.
53 of your lordship's monthly list. Well, this is against the serious.
125.
Yes, 1253 of the monthly list of July 2025.
Slip is not required. Keep it with you.
It's item number
This is
481, your
against the
lordship.
serious fraud investigating agency, but they are not allowing me to travel abroad. Well, my tickets are confirmed on 15th of July, but may it be taken up any day on the 10th or 8th, 11th of July, Maran.
Tenth of July. 1253.
Lordship,
Urgent motion. Give notice to the other side.
Lordship, may I be permitted to mention, Lordship, I have to ask another court, Lordship.
Give the
No,
number.
Lordship, not that. It's a urgent matter, Lordship. What happened, Lordship? The tender matter, Lordship, in earlier occasion,
What is to be done? Either it is there in the list or it is not there in the
Lordship, I
list.
want to leave, Lordship, to move it on 10th, Lordship. Because 11th, they will hand over to new contractor without any tender. Whereas your Lordship directed to issue tender immediately. And Lordship mentioned it immediately means immediately.
10th. You want it to be moved?
Lordship. Much hobe, Lordship.
Leave 10th. Serve notice.
My lord,
When 1124 is taken up, then mention.
my lord, 1104.
Your lordship 1303.
My lord, 989.
For withdrawals.
Withdrawal. Why?
My lord, this is a 2023 writ petition challenging a SEBI's order for attachment. Thereafter, my lord, practically nothing has been done. I have taken this brief, my lord. It is a change brief, and my lord, I need to withdraw this writ petition because there are several points which needs to be included, and it was entirely wrongly filed.
And from 23, it's in 25. This has come to the notice of the learned advocate who has just been engaged. Just imagine how a advocate is handling his client. It is not a matter of you, XYZ. How a litigant is being treated by the learned advocate. This is what it. So whatever is there, you will withdraw it, file it afresh, The entire expenditure which was given earlier goes for a toss. You come up with new briefs, new facts, and everything is new. And the entire cause of action for these 2 periods, what is going to happen to that? A lot of things are to be looked into. I am not advising you anything. This is what came to my mind immediately when you mentioned it was a 23 matter and you were withdrawal in 2025 and a leave to file afresh. Please, sorry, what is your item number?
Lord, it is not a listed matter. I'm praying for it.
Give the list slip.
My lord, 11789.
My lord, 2 analogous matter for upgradation 781 and 702.
781702. Serve notice upon the other side.
My lord, 855.
1303. All right.
My lord, 1104, my lord.
1019.
1019.
My lord, 1104.
Only 1 more minute mentioning.
My lord, 1104, my lord. My lord, 1104.
My lord, monetary claim, my lord. Monetary.
One.
I have mentioned, my lord, 1 matter, but these are the 5 matters which are analogous matter, my lord. Monetary claim. That's why.
Payment of release.
My lord, my lord.
1104, my lord. My lord, 1104.
307, similar matter, my lord. Tender matter 304 to 307.
Tender matter means? What does tender matter mean? I do not follow. What does tender matter mean?
Tender matter.
My lord,
Get ready.
my lord, upgradation, my lord, 1104, my lord.
582, my lord.
582. Move out.
My lord,
Not
11.
required. Go.
এখন নেবে না?
855. Application item number 400 of my lord's list of.
Thursday? Sorry, sir. Not allowing. There is a lady standing in front of you. You have to follow the decorum. You cannot behave in this manner. Just let her go out.
May I then mention on Thursday?
Thursday, please come.
My lord, 1104, my lord.
5 for non-prosecution, my lord.
1225
for non-prosecution, my lord.
1225. Non-prosecution.
My lord, 1691.
My lord, I have the notice today.
My lord, 1691.
No more mentioning today, please.
My lord.
No, call the list.
May I have your
Lordship.
May I have your lordship's kind leave to mention, my lord? Your lordship kindly
Is
allow me-
somebody there online?
Yes, my lord, I am there.
Yes,
My
lordship.
lord, my videography has been stopped by perhaps by the court officer.
What you want to mention?
My lord, may I have your lordship's kind leave, my lord? It's very urgent, my lord. I'm troubling your lordship, my lord. On 17th June, a notice was issued by the West Bengal Highway authorities, my lord, to the effect that they will demolish my structures where I am there since last 50 years. Now, my lord, prior to this, 2 writ applications were filed. On both occasions, my lord, once it was withdrawn and the other one was, the notice was kept in abeyance with a direction, my lord, that, my lord,
What you want, will you please say? What you want?
My lord, they are going to demolish within tomorrow. My lord will kindly fix this matter on 9th. Otherwise, I will be suffering. That is
Where
what I'm
is
trying to. Yes, my lord.
Where is the matter?
My lord, it is 1382 of your lordship's list today appearing. 1382.
1382. Upgrade. Day after tomorrow. Serve notice upon the other side.
I'm grateful, my lord. I will.
Your
share
lordship,
this.
Lordship,
I'm
leave
grateful.
may I also mention item number 13. I apologize. Just since your ladyship was taking over 1382, may I just mention 1377, your ladyship, for upgradation? I apologize to Mr. Dinda.
1377. Serve notice. Yes, Mr. Dinda.
Your
lordship, this is with regard to a review application, your lordship, pending before your lordship from April, lordship, on the returnable date, the review did not appear, and the urgency is because of your lordship's order, the electricity connection has been disconnected.
Yes.
And
Is
I
it
was
in
not
the
served the notice.
application? Is
Yes,
it
yes,
appearing in the application bundle?
Yes, application bundle.
Applications are not appearing today. Thursday, when it is there, please
Your
mention.
lordship, I appeared on a Thursday in the last month. Your lordship was pleased to direct me that you appear, you mentioned the matter on the first Monday, your lordship. So I am mentioning today.
Thing is, if it is an application,
It is
is it
taken
for
up on Thursday.
inclusion?
Yes, your lordship, it is for inclusion in the
Give the
application.
number. Pass on the number, please.
My junior is there. He will just hand over the slip.
Yes, certainly.
Great.
My lord, kindly.
Yes, somebody is there.
Lordship, I am talking about WPS 7563, public
7563. 7563,
Yes,
serve notice upon the other side. Not WPA, give me the number, serial number.
Lordship, I did not found, Lordship, it is need to mention, need to include in the list, Lordship, for hearing,
For
Lordship.
inclusion, is it for inclusion?
Yes, Lordship. Yes, Lordship.
WPA.
WPS 7.
Please
Six
put
two.
in a slip. A slip is required with the signature. A mentioning slip, proper mentioning slip is to be.
My lord, I have
Okay,
not.
Lordship.
789. My lord, 7. My lord, one matter.
For this entire month, please leave.
May I have
Yes, item.
for original side matter 1.
Madam.
Yes, item 1, who's there?
One matter, madam. Side matter,
No, nothing. I am here for the last half an hour taking mentioning matters.
madam.
You cannot help.
But I was there outside, my lord.
No, no. The door was made vacant so that people can come in.
Madam, আমার একটা contempt matter সেই 10
Item number 1, who's there for the
I
petitioner?
the petitioner. My lord,
Yes,
this is a case of
number 1. Union of India.
Union of India. Who's for the Axis Bank?
my lord, I
Notice.
we served with a
Notice.
it's been filed. My lord, the affidavit of service has already been filed. Lordship.
What is your prayer?
My lord, this is a case of, again, declaration of fraud, Lordship, without
Yes.
supplying me with either any investigation report nor any forensic audit report. In fact, the entire process, I was not even aware of any such forensic audit. This is a case, Lordship, where first a show cause
Identification committee's order?
Lordship.
You have the review committee there. Why don't you
My lord, here
approach?
it's been passed by the bank. My lord, what has happened here is first a show cause notice is issued
You
for
serve one more notice. Are you aware who appears for the bank?
my lord, Axis Bank. No,
You are
Lordship, I
aware-
just have to check. I believe in the other matters, Lordship, which I'm doing with Mr. Chaudhary, we can reach out to the concerned
Please check up if the
gentleman who's
same
up.
yes, if the
Lord-
same council appears, then it is all right.
Lordship.
Otherwise, you have to serve a notice and come back.
My lord, could it
Please
be
come.
because could it be day after tomorrow, Lordship? We'll serve it by today itself.
Come back on Thursday.
Great. As my lord.
None appears on behalf of the Axis Bank, despite service. Stop. Let a further note. The matter relates to declaration of fraud by the bank. Let a further notice be served upon the non-appearing respondents, intimating that the matter will appear in the list on 10th of July.
Grateful.
In the event the bank is not represented, ex parte order will be passed.
Lordship. Grateful.
Item 2 and item 3, my lord, I am praying, my lord, for leave to withdraw the matter with leave to file afresh, because incurable defects, certain documents were not been annexed. After going through it, my lord, it's entirely, my lord. Filed in
Is this
history,
the
my
way how to
But I-
handle matters?
I take the responsibility for it.
And a
Put the
usual order,
balance.
incurable
I have
defects, withdraw,
spoken to my learned friend also.
leave to file afresh. Nothing doing. Next one also you are there?
Well, it's
Same order. কোনটা? করুন।
Please, Your Lordship, my lord, this is my writ petition, Your Lordship. I've been pleased to hear me on the earlier occasion on this incentive not being granted, my lord, in spite of being approved. I had placed before Your Lordship, my lord, on the last occasion, the affidavit in opposition of the state. May I just trouble Your Lordship once again? And the facts will come back to Your Lordship, my lord, and I will also refresh my memory. My lord, may kindly have the affidavit in opposition of the state
Yes.
dated 21st March 2025. Siddhartha Mukherjee.
একটা নোট আছে কি দেখুন তো আমার কোনো নোট ওখানে লেখা আছে Yes.
But we will kindly take, my lord. Paragraph 7 and 8, Your Lordship had noticed, my lord, there was a delay of, or rather, I had started my commercial production 2 days prior to a 20th August. The requirement was, my lord, that I have to give them 1 month advance notice before starting commercial production. I gave them notice of intended start of commercial production on 20th July.
Yes.
I gave them notice on 20th July, my lord,
Hmm.
that I will start commercial production on 20th August. I started commercial production on 18th August. This is one ground they take. But after knowing this 2 days early start of production, they have given me incentive in excess of 30 crores.
All right.
So this has been waived, my lord, and this is not a ground which is taken in the reasoned order passed pursuant to this honorable court's directions. This is the second writ, my lord. First writ was disposed of, directing me to make a representation again, and they were to pass a reasoned order. This is not the ground taken in the order. So now, my lord, this cannot be urged, my lord. I will rely on Mohinder Singh Gill. Then your lordship kindly comes to paragraph, the main ground which is there, my lord, which is in the reasoned order also. Page 8, please, my lord. Let it be mentioned, your lordship has that.
Yes, yes.
Let it be mentioned here that the petitioner, even without intimating the answering respondents, entered into a business agreement with Adani Wilmar Limited on 2nd July 2017, and it came to the knowledge of the answering respondents only after the petitioner was directed to resubmit all the necessary relevant documents vide order dated 24th February 2021. My lord, this statement is incorrect, my lord. I'll show your lordship a document by which they were informed prior in point of time. If your lordship wants, my lord, kindly have, my lord, the page 14, affidavit in opposition of R3 and R4, please, my lord, which is WBIDC. I had informed both the state and, my lord, the concerned agency, which is WBIDC, page 13 and 14 of the affidavit in opposition of WBIDC.
Yes.
Your lordship will kindly have page 14 once, please, my lord. This was sent by mail also. And the attached document is at page 13. Sent by mail. Mail is at 13. And page 14 is the letter addressed to both. Letter is in fact addressed to the state, my lord, Department of Commerce and Industries. No objection certificate for sale of Haldia plant undertaking. And your lordship will see the last paragraph. Adani Wilmar Limited, a leader in the edible oil segment, has expressed their interest to acquire Haldia undertaking on a going concern basis. We have concerned the interest and in principle agreed to sell and transfer the undertaking on a going concern basis to Adani Wilmar, as it is in the interest of all stakeholders such as employees, shareholders, banks and state government. So it was informed to them prior to the sale, that is on 12th June 2017. Their statement in the affidavit that they came to learn of this only in February 2021 is perhaps not correct. Then your lordship kindly comes back to the opposition. Till then, that is, my lord, till February 2021, the business transfer agreement, which was executed between the petitioner and Adani Wilmar Limited, was not in knowledge of the answering respondents. After knowing about the business transfer agreement, the answering respondent number 3 was in a dilemma to release the incentive as claimed by the petitioner, and thus the time limit for the reasoned order, which was to be passed within 6 weeks, got delayed. So, my lord, I'm not on contempt. And then kindly come to page 9, my lord. They say that this transfer is against the object and purpose of the scheme. Page 9, paragraph 16, last sentence, my lord. It is pertinent to be mentioned here that the petitioner himself concealed on previous occasions that he entered into a business transfer agreement with a company, namely Adani Wilmar Limited, on and from 2nd July 2017. And this is the case which they run, my lord, which is not keeping with the object and purpose of the scheme of 2008, and therefore the claims of the petitioner were rejected by the answering respondent. Now, my lord, therefore, in my respectful and there is also one more affidavit. Kindly see the affidavit of WBIDC, my lord, which is the concerned department which releases
3 and 4.
Yes, please. No, my lord, this was 3 and 4. I'm sorry, 3 and 4. I'm so sorry, my lord.
Yes.
3 and 4, yes. The affidavit of 3 and 4. And I'll show your lordship the limited role of WBIDC in this whole scheme. Page 5, subparagraph G. These are their grounds, my lord, which they say. Subparagraph G, I have violated terms and conditions as contained in the sanction letter dated so-and-so, issued by the executive director of respondent number 3 in favor of the petitioner from time to time. Thus, in facts and circumstances, the petitioner became entitled. My lord, I have two concerns here, my lord. Executive director of the respondent number 3, that is WBIDC, is not entitled to frame any rules or regulations or terms. The terms are to be framed, A, by the scheme, which is passed by the legislature, and the delegated authority which is given. The delegated legislation authority is given only to the government. WBIDC is only the agency who is to release the payment. And I'll show your lordship from the scheme that WBIDC does not have the authority.
This is the scheme of the government.
Yes, please, ma'am.
All right.
Scheme of the government passed by the legislature.
Right.
In the scheme, my lord, which is notified by the Gazette, the
Hmm.
government is given powers to make rules.
All right.
So the government here is, my lord, the Department of Industry and Commerce, who has filed a separate affidavit. Your lordship will see the Department of Industry and Commerce, who's the government, the state, has filed a separate affidavit.
Hmm.
Now the WBIDC says that you have violated my terms and conditions. So two things, my lord. A, he does not have the authority to make any terms and conditions. And B, my lord, this is vague. There are no terms and conditions specified here. If your lordship is seeing the scheme, my lord, your lordship will kindly see the scheme once. Kindly see the scheme. There are two schemes, my lord, 2007, which was then modified in 2011. It is 11 is a better copy, starts at page 45. My lord, may kindly come to 45.
Yes.
This is the scheme of
Who is
2000.
representing the state? State is represented by
Advocate General, London Advocate General will be represented.
Your lordship, the Advocate General is leading me, your lordship, in this matter.
Oh, where is he? Will you be there at least?
Your lordship, I'm here virtually, your lordship, but
All
the
right. All right.
Advocate General
Remain
will address.
virtually. Yes. Page 45 is the schemes.
Page 45, the scheme starts, my lord.
Hmm.
Now kindly come to page power to amend, relax or repeal. Clause 18 at page 56.
Yes.
Notwithstanding anything contained in any of the provisions of the scheme of 2008, the state government may at any time make any amendment to this scheme or repeal it, make any applications in relation to the scheme which is not so relevant. Malad, kindly see 18.3. May issue instructions and guidelines to facilitate implementation, to remove anomalies, and to clarify the interpretation of the provisions of the scheme. It is only up to the state. WBIDC, my lord, is not the state. This is but a corporation of the state. And my lord, now, since your lordship is at the scheme, kindly see the relevant portions of the scheme once, please, my lord, where I am entitled to. Kindly come to page 50, please, my lord. The last clause at page 50, clause 9.5.
Yes, please.
Industrial promotion assistance. Industrial units falling in the scale of 2, 3, and 4 will be granted industrial promotion assistance or IPA. The total industrial promotion assistance, that is TIPA, for the eligible industrial unit would be eligible shall be equal to certain percentage of the value added tax to be paid by the unit in the previous year. The percentages proposed for the unit in the different scale of rates are as follows. My lord, I fall under scale 2, which is 70%. Now, my lord, kindly see how it is worked out. The TIPA, that is, my lord, the total industrial promotion assistance admissible to an industrial unit will be broken up into two components with equal weightage of 50% of TIPA to each. That is, against fixed capital investment called SIPA and against employment creation called IPA. SIPA will be disbursed to an eligible project for the number of years indicated below or till 50% of FCI, which is the fixed capital investment, is reached, whichever is earlier, scale to 8 years. Therefore, my lord, from the start of commercial production, I have a maximum period of 8 years to, my lord, my lord, receive the benefit which I am entitled to, or 50% of fixed capital investment, whichever is earlier. Now, my lord, kindly see 10.13. Is how the assessment takes place. There is no dispute about the quantum here. I have been held to be eligible. There is no dispute about the quantum, and the relevant clauses which your lordship will see, which show that the scheme is only for this limited period. If once I achieve this target, there is no prohibition in the scheme that I have to continue my ownership of the unit. What their contention is that you have transferred the unit on a going concern basis to another entity. It is not that case that that entity has stopped production or the unit is shut down. In fact, I transferred it to somebody who's much bigger in size than me. He has expanded the unit. Adani Wilmar is much bigger, my lord. The unit has expanded. So now your lordship sees in the entire scheme, there is no, my lord, embargo on transfer after achieving the entitlement. Kindly come to now, please, my lord, these terms which are there. So the government has the authority to make terms. I have to satisfy your lordship. There's no embargo in the scheme. There is no embargo framed in the terms stipulated by the government. There is an embargo in WBIDC, but WBIDC doesn't have the authority, and that would be, my lord, against the provisions of the scheme itself. Kindly now see, my lord, the terms which are framed by the government. Kindly come to page 60, my lord. This is the first certificate which is granted, my lord, RC1. Registration certificate, your lordship kindly comes to. Registration certificate for assistance under the WBSIS scheme of 2008, part 1. There are 2 certificates which are granted, my lord. One initially on registration, once I commence commercial production. So then they certify that yes, commercial production is commenced, now you are entitled to. So your lordship sees part 1, this is the date. Now, my lord, kindly see the bottom. These are the terms. The provisional registration certificate is issued subject to the condition that actual flow of state support will flow only after issuance of registration certificate part 2 by the Department of Industries, West Bengal. The unit must submit quarterly progress reports for the concerned project to this office on a regular basis. The unit must immediately inform this office of any changes in the project parameters, employment, investment, locational changes, etc. Even if I say that change of ownership, it is only information. It is not a bar, and it's not requiring consent, and change of ownership is not here, my lord. If at any stage it is found that the particulars furnished by the unit are incorrect, this registration certificate shall stand cancelled. Figures stated are unverified data as submitted by the applicant. Now kindly come to the registration certificate part 2 at page 61. This is the registration certificate part 2 which is granted. You are requested, kindly see the second paragraph, you are requested to note the terms and conditions given on the reverse of the enclosed certificate and follow the instructions given herein so that the reliefs or subsidies could be properly processed. It may please be noted that non-compliance of the stipulations may result in non-availability, etc. Now kindly see page 62, please, my lord. This is the registration certificate part 2. Kindly see project status new, classification B, there's no dispute, scale 2. Actual amount of fixed capital investment is 111.69 crores. Validity period till part 1 is valid. If commercial production is commenced, no further validation is necessary. And now kindly see the terms which are there at page 63. The unit registered under so-and-so is eligible for the following assistance. Total industrial promotion assistance will be 70% of the VAT paid by the unit in the previous year. Out of this 70%, IPA, that is the investment against fixed capital investment, will be 50% of this 70% of TIPA for 8 years.
This is the quantum that is mentioned. How
This
much
is the
you will
quantum.
get.
So, your lordship will kindly see 8 years or till 50% of FCI is reached, whichever is earlier. And then your lordship sees the next. IPA against employment creation will be balanced 50% of the TIPA. This will be 50% of the FCI or 15 years from the date of commercial production, whichever is reached earlier. The release will be as per this. So, my lord, both gave a timeline within which it is to be achieved. If I achieve it before the timeline, I am to be paid this money because they say it will be 50% of your FCI, cannot go beyond that. And then your lordship kindly sees the only terms and conditions which are given. RC Part 2 is issued subject to the compliance with the terms and conditions as stipulated in Part 1 of the RC, as well as the terms and conditions of the scheme. No embargo here. And then kindly see, the unit must submit quarterly progress report in the enclosed format for the project to this office. So the registration certificates do not.
But tell me one thing,
Please.
you need the incentive for the development or betterment of your unit.
Yes.
Unit is no longer with you, unit you've already transferred. Then why will you get the incentive?
Yes. So, my lord, I need the incentive. Now, kindly see the term, why the scheme was brought in. The scheme was brought in for setting up a unit in the state.
Now your unit is set up and you
My
have
unit
already
is set up.
transferred.
No, my lord, I have set up the unit. The minute I set up my unit, my lord, and I commence commercial production and I generate value added tax. That is, the production is ongoing. And the scheme specifies that you are entitled to only so much and a time frame within which you are entitled to achieve this so much. But I have already achieved that. I have complied with the parameters of the scheme.
Maybe.
Yes, my lord.
But then even thereafter, the scheme is only for that particular unit, which is no longer yours.
Yes.
What will the incentive be given to you?
Because, my lord, 2 reasons, if I may humbly submit. The scheme.
This is not a matter of right. This is
No, it's
pursuant to the
compliance.
scheme.
Compliance of the scheme. So this is the
Right.
scheme. Well, the scheme document, if I may put it this way, constitutes a contract between the parties. Whatever the terms of the scheme I have to comply with. If I do not comply with, I'm not entitled to incentive.
Can this scheme be treated as a contract?
With the greatest of respect, my lord, perhaps yes, because this is an offer by the state. Kindly see, my lord, the scheme once, please. My lord, what the state requires me to do.
Yes.
Kindly see the notification.
Yes, you read out.
I have read this out, my lord. Necessary and expedient to extend certain financial support for the promotion of industries in the state. This is the purpose, my lord. If I set up an industry, I invest so much, I am entitled to an incentive if I carry on production. Now, kindly contemplate a situation, this situation, if I take it from the other side's view. I set up an industry and I just set up the industry. I do not generate the production. Production is, my lord, what is beneficial for the state. Employment and, my lord, commercial tax, both comes from the actual production which is carried out. The scheme provides that 8 years and 15 years. These are the two. And, my lord, they give me the incentive only if I generate that production. It is something which I've already paid the state in the form of value-added tax, which the state gives back to me. And they say that for giving this scheme, the state in its wisdom formulates that this is not only setting up will not suffice. You have to run this so much, you have to run your industry for so much, and you will only be entitled to return in the form of VAT. Well, I have run the industry for so much. I have generated the amount of VAT which I am required to generate before the period of 8 years and 15 years. So my entitlement in my respectful submission has now become absolute because I have complied with all the terms and conditions. There is no term or condition in the scheme that you will not be allowed to transfer this unit for all times to come. There has to be a specific, this is a business model, my lord. There has to be a restriction on me specifically that you are not entitled to transfer this unit ever. Once you avail of the incentive, you cannot transfer this unit. There is no such prohibition either in the scheme or in the rules framed by the government. Now this, I must show your lordship, my lord, what the WBIDC puts in. The WBIDC now, my lord, puts in a kind of, when it issues me, my lord, the entitlement certificate. Kindly see now the entitlement certificate which WBIDC gives. But for this, my lord, may I just trouble your lordship once with the scheme? Kindly see page 79 and 80. The limited role of WBIDC. How the operation is to be done is page 79. Your lordship will kindly come to.
Is this an addendum or what?
No, Mala, this is the scheme, part of the scheme.
Page 45 is dated 2009.
Yes, this is, Mala, the 2008 scheme which was amended in 2011. So it's a continuation.
All right, amended.
It's a continuation, Mala.
Amended.
Kindly come to page 79, please, Mala, as to how the scheme is to be operated. So your lordship will see, if your lordship just glances through, it provides the first page, provides the application form, RCs, etc. Then kindly turn to page 80.
Yes.
Kindly see page 17.8.3 at page 80. Yes. The role of the WBIDC, my lord, starts only for the purpose of disbursal of incentives. This is the limited role of WBIDC. Not for the purpose of framing any rules, regulations, nothing. Kindly see 17.8 where it starts, my lord, a unit after receipt of the RC part 2 from the district industries may apply to the WBIDC for the incentives to which it may be entitled to under the scheme in the manner prescribed below. And then kindly see 17.8.5 which provides for the verification by WBIDC.
Yes.
Before disbursement of incentives, WBIDC will make necessary verification to ensure that the nature of activities of the unit continues to be the same and the units are in operation.
How do you fulfill this?
Well, nature of activities is the same. I am still refining vegetable oil. And Malad, the only catch is the units are in operation. The units have to continue to be in operation.
At the hand of somebody else.
Could be, Malad, because there is no embargo here. The unit cannot shut down. I would have understood if this provided here also that the unit has stopped operation. And WBIDC's limited role, your lordship finds, is only limited to this, only verification, not rule making. Rule making power is reserved by the Department of Industries under the state.
After you transfer it,
Please, my lord.
the name of your unit changes?
Name of my unit changes. It becomes a new ownership, my lord.
Absolute new ownership. And so can you say that the same unit is in operation now? With the change of name, the identity of the unit will change.
My lord, the identity, my lord, would then again bring in an embargo on ownership. When
that may be implied.
My lord, with the greatest of respect, not, my lord. Kindly see this. All that WBICD first does is verification of, limited to verification. Nature remains the same.
Activities of the unit. The
Yes.
unit is no longer there. The name has changed. The identity has changed.
Yes, my lord. Name has changed, identity has changed. Now, whether this would be an embargo here, my lord, two things I submit over here, my lord.
Yes.
Before disbursement of incentive, WBIDC will make necessary verification. So, my lord, before, now this is incentives which are pending for over 3 years. From 14-15, 15-16, 16-17. Previous 2 years, incentives have been paid. WBDI.
You got part of the
incentive? Yes, I got part of the incentive.
It's only after the transfer that they have stopped.
And prior to the transfer also.
Immediately
2 years.
prior.
No, my lord. Through the transfer happened in 2017.
All right.
2017, May or June, that date which was
Whatever.
there.
Yes.
So the 3 months of 2017 and 2 financial years prior to
there too.
these have stopped. So, my lord, the units are in operation or the nature of activities remain the same. Does not say that the units have to be in the same ownership.
Very well.
And then your lordship kindly sees. Yes, we are only, my lord, claiming incentives which have been already accrued in my favor under the scheme prior to transfer. It's not that I'm claiming any incentive which is
After transfer.
Yes. It is not after transfer. And then your lordship also sees the certificate which is issued by WBIDC for the previous years, my lord, where the incentive has been paid. Kindly have page 103 of volume 2, please, my lord. Because this is something they will rely on. So, in the writ jurisdiction, I have to place all the facts, my lord.
1023.
103. This is the certificate which was granted by the for the previous years. Kindly see, my lord, it relates to the first year, 2009-2010. Corporation has admitted 1 crore 86 lakhs towards SIPA out of the total TIPA of so-and-so. Then kindly see on the following terms and conditions. This is where I beg to join issue, my lord. They do not have the authority to frame any terms and conditions. The subsidy will be released as per clause so-and-so. Balance amount of TIPA will be considered as IPA. Now this is C. The company shall not in any way dispose of any or part of the asset already created.
This was in 2011.
Yes.
You accepted the money.
Yes.
Never challenged the terms and conditions.
Yes. My lord, these terms and conditions, if they are non-est with the greatest of respect, framed by an authority which does not have jurisdiction, it's a nullity, in my respectful submission.
Yes, but then you did not challenge.
I did not challenge it.
You accepted it. Now, when they put this into operation or
Yes.
they show this as their trump card, then you
Yes.
say these are non-est.
Yes, my lord.
Very well.
That is the case, my lord.
I'm just
Yes, your lordship.
my mind out.
My lord, I will
that you can
I will address your
justify the court.
Yes. My lord, if I may, without my lord citing any authority, if I may react to it in this way.
Yes,
It's an order passed by a quorum which is non-judice. It's a nullity. The scheme did not, my lord, entitle them to impose any such term or condition. And then there are the others, my lord. So this is now C. Without, now, my lord, if you're
E is also there.
The company shall not change location and shall also not transfer any of the asset to other units. Yes, please, my lord. In some aspect, not entirely any of the assets to other units, my lord. Means could be a part.
Could be a part.
Could be a part.
Part
yes.
of the
Could,
unit.
Yes.
Transfer it
Yes.
from one unit.
Yes.
To,
so, if,
my
lord, what happens in
there
this?
Also.
Yes. So, my lord, what happens in this refinery of edible oil business? There are two units basically. One is the refinery. The other is the packing unit.
All right.
So, my lord, the refinery, they import the crude oil refine it, and then they pack it into those cans, which we see, my lord, cans and tins. So this is perhaps prohibiting that you cannot even, because the total is calculated on the entire unit, which comprises of 2 individual units. So perhaps E contemplates that, but the absolute bar is in C. Absolute bar is in C. And this, my lord, continues for all the years. Now, if your lordship kindly sees the reasoned order once, please, my lord. The reasoned order, which is assailed before your lordship, my lord, is that page.
Yes, please come to the reasoned order, but then it appears that since 2011, you knew,
Yes.
it may be an honest clause, but then you knew that there is a bar.
Yes, my lord.
Whether
And
that is proper or not is something different, but you are aware of it.
Yes, my lord, now I am aware that this bar is sought to be raised. Therefore, my lord, I write that letter to them. That letter which I wrote to them pre-transfer. Kindly, your lordship saw that letter, which the state says I had no knowledge of. Letter was written to them that please give your no objection. I propose to transfer this in the betterment of the state and all stakeholders, because it's going to a bigger. There is no response. I'll show your lordship the response which comes to that letter. Kindly come to the reasoned order now, please, my lord. Page 196, which is the findings. The first part of the findings at page 196, my lord, do not give any reasons. Your lordship will kindly come to the last paragraph. They just set out what the procedure is. Subsequent to receipt of the certificates from the commissioner so-and-so, WBIDC ascertains the entitlement. This has to be read with clause 17.8.5, which pertains to verification by WBIDC. This is what I showed your lordship, my lord. Verification by WBIDC. Prior to disbursement of incentives, WBIDC makes necessary verification to ensure that the nature of the activities of the unit continues to be the same and the units are in operation. So also to check if the conditions stipulated in the sanction letter of 2008 are complied with. So the state is also saying, my lord, it all harks back to the scheme, not to, my lord, the letter of entire sanction letter issued by WBIDC. It always harks back to the scheme. Then kindly come to 197, please, my lord. It is also noteworthy that the incentives are released to the applicant based on the funds received from the department. Then the next paragraph talks of time lag, my lord. Why there's a delay in releasing incentive for 2.5 years. Then, my lord, kindly come to the penultimate paragraph on that page. While the aforesaid process of verification was being undertaken by WBIDC, the latter learned that the petitioner is engaged in the sale and transfer of its undertaking of its Haldia unit to another entity, Adani Wilmar. This is perhaps incorrect, because prior to transfer, intimation was given in June. Transfer took place in July. This fact was confirmed by the petitioner's communication to WBIDC by letter dated August 2017, whereby the petitioner informed WBIDC that since it is understood that no objection certificate will not be required for sale and transfer of its Haldia undertaking to Adani Wilmar, the parties shall accordingly proceed to consummate the sale transaction. WBIDC responded with a letter dated October 17. This is what I want to show your lordship, my lord, and denied the contentions of the petitioner and requested the latter to substantiate its contentions through relevant supporting documents. It was also emphasized by WBIDC that it cannot go beyond the scope of the scheme of 2008. And I'll show your lordship this letter. Then kindly come to the next page. It is also crucial to point out that in this interregnum, changes had also been brought to the tax regime by way of introduction of the West Bengal Goods and Service Tax Act 2017. This was a departure from the erstwhile value-added tax regime, and therefore such a change in the tax regime also brought about a void in the policy sphere. So, GST came in, VAT went out. Pertinently, the amounts sanctioned in the sanction letters for SIPA and IPA issued to the petitioner were subject to certain conditions. These are as follows. Then these are the conditions, my lord, which come to the subsidy will be released as per clause so-and-so of the scheme, availability of fund to WBIDC, the balance of TIPA, company will not. Now, these are the conditions which they bring in from WBIDC's letter. And WBIDC says, I cannot go beyond the scheme of 2008. When I give them the letter seeking no objection, WBIDC says, you do what you want, but you cannot go beyond the scheme of 2008. Now, the state brings in, my lord, these letters are not, these terms which are encapsulated here are not terms from the scheme. The scheme terms stop at the first 2 bullets. The rest are all, my lord, from WBIDC.
Yes.
Overdue amount to WBIDC will be, and these terms and conditions as contained in the sanction letter have been issued clearly to the petitioner. Petitioner was clearly aware of its obligations not to term. This is what fell from your lordship, my lord. You were aware of this at the relevant point of time. Such terms, now, my lord, kindly see, such terms and conditions and their binding and mandatory nature were also conveyed to the petitioner at the time of grant of registration certificates 1 and 2 by the Directorate of Industries. Pausing here for a minute, this is incorrect. The Directorate of Industries, I've shown your lordship the two RC certificates, the registration certificates which are there. They nowhere incorporate that WBIDC will make further terms and conditions. They say this registration is valid as per the terms of the scheme and the conditions given overleaf, which makes no mention of sanction letter of WBIDC, which is issued much later in point of time. So this, where they try to make the terms binding, is through the certificates of the directorate, because they also know that otherwise these terms have no sanction. So they try to bring in the binding nature by the terms of the certificates, which is incorrect. However, the narration of the facts clearly reflects that the petitioner is not in compliance with the terms and conditions, and then they give the reasons. The very purpose is to support large and medium scale industries. Petitioner's sale of undertaking to Adani was not keeping with the object and purpose of the scheme, which was sought to be advanced through the terms and conditions. Kindly see, my lord, which was sought to be advanced through the terms and conditions in the sanction letter, as also the scheme of 2008 itself. The sanction letters do not form part of the scheme. And then this is rejected. Now, my lord, there's just one document I want to show you, lordship, my lord, the response of WBIDC to my letters, which they have also referred to. Kindly come to page 16, please, my lord.
Yes, please.
This is the letter which WBIDC writes to me, my lord.
60?
16, please.
16.
The affidavit in opposition of R3 and 4, my lord.
Oh.
Page 16.
Yes.
This is the letter which they write in response to my letter.
Hmm.
In reference to the above mentioned letter, you are requested to submit your contentions as per the appropriate provisions of the scheme of 2008, along with all relevant and supporting documents. Kindly note that WBIDC cannot go beyond the scope of the scheme in any manner, and your contention in the above letter are denied in seriety, and your prompt action in this regard is solicited. So they themselves say we cannot go beyond the scheme, and they deny my allegation. This is a bare denial. The transfer has happened. There is no embargo on transfer either in any other industrial policy. That once I set up a unit in Haldia, I cannot transfer the unit. The no objection was sought, my lord, because the buyer wanted a clearance from the government that whether this unit in this special economic zone can be transferred or not. Then when we went through the schemes and everything, not this scheme, the industrial scheme, my lord, of Haldia, whether transfer of ownership is permitted or not, there was no embargo. And so the scheme went through. Till today, my lord, they have not challenged the change of ownership from the petitioner to Adani. There is no.
Where is the reason for challenge by the government?
Yes, so my lord, if there was an embargo that the unit cannot be transferred, kindly consider if there's an embargo on transfer of unit per se.
Right.
If that you set up a unit, then you must run the unit for X number of years. Your unit can.
That can never be.
So, my lord, the same applies to this. I'm grateful, my lord. How can, my lord, transfer of an asset be prevented by any law? There cannot be. It cannot be prevented.
Certainly.
Now, my lord,
whether on this ground you will be entitled to the incentive, that is the question.
That is what is troubling, your lordship. Lordship will my learned senior will assist your lordship, my lord. If there is any such embargo contemplated in the scheme, it all boils down to that. Whether the scheme and the registration certificates, which is the delegated legislation, whether these two documents contain any embargo or not.
Yes.
Those are my respectful submissions.
I'll hear you on the next day. I'm already beyond time.
Lord, may I come back sometimes next week, subject to your lordship? Of course, my lord, your lordship has heard my learned friend.
Yes.
Would it be sometimes next week or Friday this week, Friday? I would prefer, my lord, next week because
Fridays
the
are
open benches.
I understand. Next Monday, will it be all right?
Yes.
Please come.
No, Monday, 14th. Okay.
Learned Senior Counsel representing the petitioner concludes argument. Stuff. Fix on 14th for hearing the respondents.
I'm grateful. Grateful.
Don't call any other matter.
My lord, I'm for the petitioner, my lord. My lord, this is a case, my lords. We have lodged this writ petition under West Bengal Fisheries Act. Land was that Pukur pond that was encroached by the occupier. That is respondent number 9. So I made representation to the collector as well as BLRO.
I see it is.
It will be under
Released.
land, my lord, because BLRO admitted that encroachment was done and he directed that to demolish that thing. Collector and land is the actual
The
authority.
matter has appeared in the list for correction of the order dated 30th June 2025. Stop. Learned advocate for the petitioner submits that the matter relates to land jurisdiction and not the panchayat. Stop. Let the matter be leave not leave. Let the matter be placed in the bench taking up land matters. Stop.
P6, my lord. You can see, my lord, speaking order is there. P6, annexure P6, 34 in the petition.
Where is your front sheet? Leave granted to the advocate on record of the petitioner. Where is the on record?
On record, Indrani Nondi is there, my lord.
Yes.
She has not come today because this is correction order, my lord.
But then the front sheet is required to be corrected under her signature. Tomorrow she is coming.
Tomorrow she is coming.
All right. Leave is granted to the advocate on record of the petitioner to amend the front sheet of the front sheet and the presentation form of the writ petition. Next.
Lordship, I am for the state.
My lord. Does not want to proceed with this.
Why? Very well. Please come. Learned advocate for the petitioner submits that the grievance of the petitioner has already been redressed by the authority. Stop. The petitioner does not intend to proceed with the writ petition any further. Stop. In view of such submission, the writ petition stands disposed of. Is there a written communication? Written communication given by the petitioner to the learned advocate be retained with the records. Next. Non-prosecution.
My lord, I am on behalf of the petitioner.
Yes.
Buddha Mukherjee.
Who is the advocate on record? Are you the advocate on record?
Yes, I am.
Yes. You do not want to proceed with the matter?
No, Buddha Mukherjee has told me to withdraw this particular
Why?
petition. Because he is telling that I have already paid it out. I have informed the bank to that deduct all the money from my pensioners' books.
I don't know. There is a written communication from your client?
No.
Then?
No, I told them that please you collect one certificate from the bank.
What you have said your client is not required. For you to withdraw, I need a written communication from the petitioner to be kept on record. Is there anything with you?
Yes, yes.
Where is it?
I'll just indicate. The issue was
1 minute. Whatever is the issue, you take it up. I'm just dismissing it for non-prosecution. The petitioner has given a written communication to the learned advocate disclosing his intention to withdraw the writ petition. Stop. In view of such submission made by the learned advocate for the petition, comma, the writ petition stands dismissed as withdrawn. Stop. Written communication by the, who is this Reena Mukherjee?
Reena Mukherjee, wife of the Buddhadev Mukherjee.
Has the petitioner given her any authority?
Probably there.
The petitioner is Buddhadev. It was affirmed by Ranjan, and now the letter is from Reena.
Ranjan is the son of the Buddhadev.
I do not know. I don't want to know. Who is Reena?
Who is the wife of the Buddhadev Mukherjee?
Where is the authority given? Now Buddhadev will come and say, I have not given authority to my wife.
She's quite sick at the age of 84. That is the problem.
The problem is yours, sir. If Buddhadev or his heirs, I do not know, comes and says that this authority was never given, then it is for you to take care. The court is not going to take any responsibility. Neither is the bank. The matter is being unresolved. So the bank is going to take steps. I do not know anything. Given by one Reena Mukherjee, allegedly the wife of Buddhadev Mukherjee, who is presently unwell. Filed in court today is taken on record.
One affidavit is also there. My lord.
Call the next matter, please.
Dilip Motors, advocate on records.
Yes.
Should I appear for the response?
Is state the answering respondent, or is there anybody?
The medical counsel.
Anybody representing the council?
Yes.
Yes. Who is representing?
But I am representing the council.
Oh, you are there for the council. All right. And who will be representing the respondent number 1, the state? Yes, I can see the state has been served. Somebody from the state.
Yes, well, I'll arrange someone, please.
Yes, please.
Recognize the doctor. He has been practicing for quite some time because he has pursued his PDS course. Other courses, there is a problem with that. Everything is in order. Not he has got a successful. He was successful not in persuading or obtaining an honor from Glasgow, FRCP Glasgow, in the year 2019. And upon obtaining the honor, it is not apparently some degree. And according to our instructions, it is not ordinarily a matter which is compulsorily registrable or is registrable per se. Good, bad, indifferent, he was continuing with it. He had contested the IMA elections, Indian Medical Association election. He was successful there. Now, in order to somehow teach him a lesson, because the election was put to challenge in a collateral proceeding in the suit, the challenge was foiled. Challenge did not succeed. Be that as it may, now a different mechanism was adopted. Mechanism is a suo motu proceedings was initiated first.
By whom?
By the medical council.
All right.
West Bengal Medical Council. You need not open the papers. I'll just show your lordship how the malafide is. Lord, called upon to attend a hearing sometime in the month of May 2025. Before that, since he was being pestered by the council or some members, some good well-wishers, he had unilaterally given certain documents to the council to get it verified and get it registered also, and upon payment of 10,000 rupees fees.
Unilaterally means there was
on his own accord.
There was no request or nothing.
Formal request, no. alleging that he has been using this particular this honor, this degree according to them, this qualification according to them, albeit without taking the permission or registration from the council. This suo motu proceedings was initiated. He participates in the proceeding. He was given certain questions to which he answers in writing. Then, in the month of June 2025, on 9th of June to be precise, he is served with a charge sheet, alleging that this is the allegation against you. You are using it. You are misrepresenting this thing. This amounts to, some professional
misconduct
according to the council. He again gives a 12-page reply to that communication, to the charge. First submission to your lordship is, the charge sheet is apparently based on some report not disclosed to him. In the reply, he seeks the report. The charge sheet is apparently based on some undisclosed complaints not disclosed to him. He, in his reply, categorically mentions that these complaints, these responses have to be furnished. Please give it to me, apart from giving his explanation, including the fact that this is not registrable. Now, the council calls him for a hearing last Thursday. Last Thursday, the hearing was scheduled at 12 noon. The hearing commences around 2 o'clock. On my way back from court, I receive a call around 4:30 that the president of the council has announced it by way of a press conference, media conference, that this gentleman, this doctor his license has been suspended for 2 years. Nothing formally communicated. In fact, one of my learned friends attended the hearing along with the writ petitioner. He gave a document, submitted a representation saying that if you are arriving at any decision, please communicate it. Without doing anything, flashed in the media, because the man is otherwise known, and he and the president and the secretary of the regional or the local unit of IMA, they are at loggerheads with each other. Owing to various other issues, I'm not going into that. Third, announced, entire country knows. Fourth, comes out in all major newspapers. I approach your lordship immediately, on the basis of that communication, that if any decision is there, it should not be given an effect to. Your lordship was kind enough to allow me to move today. On the 4th, my instructing advocate pays a visit to the website of the council to find out if there is anything of significance. At around 7:45 in the evening, he communicates to me, in person, that this is a decision which has been uploaded. I have come with that decision by way of a supplementary affidavit. Leaving aside every other thing, whatever we have learned from my lord, my learned seniors, if this decision is the decision.
Is it not formally communicated to you till
not
now?
Today, even today, no. Not even by mail. What has been communicated are 2 caveats, pertaining to district judge, court in Barakpur and Barasat. This is my supplementary. Before I invite your lordship to anything else, please see the decision uploaded on the 4th. Please see page 12.
Yes.
This is to inform you that West Bengal Medical Council, at its extraordinary meeting held on 3rd July 25, after considering the charges as framed out by this office inquiry dated 9 June 25, as was communicated to you for hearing of the charges, upon hearing on 3rd July, found you guilty of infamous conduct in a professional respect and decided the name of Dr. Shantanu Sen. No reasons, no consideration worth its name. Now, please come to, I request my lord, kindly come to the representation. First is page 50. I'm coming. Please come to page 50. Please come to page 50. This is 9 June.
Yeah, this is for page 12 is 4th July.
4th July uploaded. Considering 9 June charge sheet, can you, has my lord very
9
kindly.
June is page?
Page 50.
50, yes.
On behalf of West Bengal, I'm sorry.
Yes, yes.
On behalf of West Bengal Medical Council, I give you notice that information and evidence have been laid before the council. We're not pausing here. Such information and such evidence has to be disclosed to the person. Elementary. By which on the basis, before the council, by which on the basis of the complaint. We're not leaving aside every other thing. In my response, your lordship will immediately not pose this question. In my response, I specifically seek a copy of the complaint.
Page 50, by your way of page 50, where you directed to give a response.
Yes.
Where is it?
Give you notice, considering the penal and upon perusal of the available records.
Where are you reading? Where are you reading? Page 50?
Page 50.
You are hereby requested to bring the certificate of registration in original and to submit the same before start of hearing, failing which your case will be heard ex parte. All right. So you are requested to bring the certificate of registration in original.
Yes.
Thereafter?
I give a detailed response to this, including, please see page 60, apart from anything else.
Page 52, it starts?
Yes, it begins at page 52, it ends at page 68.
All right. Your response, yes.
So the paragraph 6, the page 60, last paragraph. So the suo motu proceeding as per charge sheet surprisingly transferred to a proceeding which has been initiated based upon a complaint made by someone of which I have no idea or no copy of the complaint till date has been made available to properly defend myself by the council. It is not only very confusing but subject matter of grave suspicion of a greater conspiracy and a charge of shifting the stand in a whimsical and pure sign of malpractice. Milord, apart from this, I raise various issues, including the fact that what is this qualification about? Milord, if your lordship sees the degree, page 30. But it is a distinction. This is Royal College of Physicians, Surgeons of Glasgow, having acquired distinction as a physician, was on the 2000 admitted a physician fellow of the Royal College of Physicians and Surgeons of Glasgow. Nothing else.
Oh, what does this mean? Did the candidate pursue education over there, attend college, online, or what?
On the basis of whatever he furnished from here.
Well, furnish what? Thesis, paper, dissertation, something.
Including his acumen in practice, his proficiency in practice. Considering that, this is done.
So this is not a regular educational certificate type of
this
thing.
This is not a regular educational. This is not a not a qualification person.
Not qualification.
It's an honor.
All right.
It's an honorary title.
Right.
It can be construed to be that.
All right. And how much weight does it carry?
It is just a feather in the cap, if I may say so with greatest of respect. It doesn't carry, it has got no semblance of, coordinate.
And does it,
feather in the cap, to ordain the letterhead. Apparently,
Nothing.
my understanding is it does not add any extra value to his proficiency as a doctor.
Qualification. And this certificate is not used for his treatment or nothing of the sort.
Treatment?
Very well.
Yes, he is a radiologist by profession. He is a doctor.
That must be because of a qualification that he obtained by studying. Exactly.
Yes. Now, this being the position, this is the ultimate decision under challenge at page 12. Apparently the supplementary affidavit is just to bring on record this, including adding this point that it is bereft of any reason. No reason, no consideration worth its name has been given to whatever. It merely records the ipse dixit of the authorities. It does not allow a peep into their mind as to why whatever explanation
Yes, I get it.
Was not
I
found
get
to be
it.
creditworthy.
Right. So is this a ground of challenge?
This is prima facie.
Right.
I will be requesting my lord to kindly interfere at this stage. My entire my lord, what they have done, what they are doing, though, my lord, this issue is ancillary to it. It is recorded in the supplementary affidavit. My lord, though this issue is ancillary, my lord, these persons, they are certain people, my lord, who are hell-bent in seeing that somehow I am shown the door from IMA and I am castigated by the entire world for having done something which I have not actually done. So, my lord, kindly protect me, my lord.
Is the person an independent private practitioner? Is he government attached to any government hospital, or
he is a private practitioner?
Private practitioner. All right.
Completely a private practitioner. He attends like chambers.
Yes.
And, my lord, if your lordship wants, I can cite judgments, just to, prime office.
Yes, please. First thing, unreasoned order. Second is copy of the complaint that you rely upon, not furnished. Any, what are the other languages used? Page 50.
Page 50.
Page 50. Information and evidence that you rely upon at the time of passing the order not communicated. Your response.
First is, my lord, what is the admitted case? 2019, please have a look to page 30. My learned friend has placed that. Kindly comes to page 230. I'm sorry, 200, only 30.
Yes. The certificate.
This is the certificate. What is very important is, your lordship will find at the top, Diploma of Fellowship, FRCP, Glasgow. Diploma of Fellowship. The admitted case is that this is an honorary degree. Where do I get that? Paragraph 6 and para 16 of the writ petition. Admitted. Please have a look to, my lord, one or two documents, namely his letterhead pads. For example, if your lordship may kindly take the next page, page number 32.
1 minute.
Yes, yes. Yes.
This is a letterhead dated 22nd of June 2024.
Yes.
What does he write? As suffix MBBS, DMRD, gold medalist, FIAMS, FRCP, Glasgow. What does a public like me get from this? That he is a degree holder from the, what is called Fellow of the Royal College of Physicians. It is not mentioned that he is a diploma holder. This is admitted case. Thereafter, there are other.
No, there may be 101 deficiencies.
I'll come to that. I'll answer, my lord. Whatever.
Only a non-reasoned order without supplying documents, not considering his response. Nothing beyond this.
2 or 3 documents, my lord, I need to, my lord, place before your lordship, my lord. First is, my lord, we give him a letter on 15th of May 2025. Please have a look to that, page 43.
Yes.
We have informed you earlier. This is 15th of May.
Yes.
Yes. Kindly see, my lord, the subject of this letter, suo motu proceeding. Where my learned friend was asking for complaints. Suo motu proceeding to be initiated against so and so. This is evidence of breach of ethics. We had informed you earlier that you have been using your additional qualification FRCP Glasgow in your letterhead, which has not been registered with the register of the registered medical practitioners being maintained by the council. The alleged breach of medical ethics is being investigated by one of the penal and ethical cases committee of the council, and the said committee decided to take your deposition in the next meeting at so and so. You are requested to appear on so and so. Now, my lord, he answers to this next page. I acknowledge the receipt of the above referred notice, which have been needlessly served upon me twice on, etc. After going through the purport and contents thereof and going through the same, I am compelled to give my reply confined only to the alleged breach of ethics. It is needless to say that the only points based upon which the alleged suo motu proceedings, he accepts suo motu proceedings, have been incited are whether I can use the additional qualification in my letterhead without registration of the same as per the Act. Use of additional qualification amounts to breach of ethics in medical practice. I confine myself to give answer only upon the above points. Following the provisions of the Act, after I have successfully obtained the additional qualification, I have already applied for further registration of the additional qualification after depositing the fees. Though I came to know my application has been verified properly on 10th of March, but till date, neither it has been made available to me nor it has been rejected, the reasons best known to the authority. The next paragraph is very important. As it has not been denied by the authority, being a senior medical practitioner of a state, it can be deemed that my application has not been rejected and I am entitled to use the same as my qualification. Now, this is his defense, that I have applied for registration, verification done on 10th of March. I have not heard anything. Therefore, it is deemed to have not been rejected, and therefore, according to him, he is entitled to use it. Now, Miller, your Lordship may kindly take note. The rest, Miller, I don't think. Yes. Yes. Now he goes for an interpretation, which is on the next page, that is page 46, top. If the provision of the Act is properly interpreted, then it can be understood that.
No, interpretation part, we'll go to it later.
No, if, Miller, please take the second line. I'll not trouble much, page 46. It is obligatory for a medical practitioner to inform the authority about his additional medical qualification and asking for registration of the same as per rule. And it is obligatory and strict duty of the authority to record and register the same without any delay. Therefore, registration, according to him, is a requirement. According to him, counsel was sitting tight. Good but indifferent, this is the case made out. Now, whether, Miller, this can permit him to use the qualification. My learned friend was asking for a complaint. I'll answer that. What prejudice is he suffering? Because it is his case that he has applied for registration, verification done, not rejected, therefore he's not communicated, therefore deemed not rejection, or in the active way deemed permission. This is what is his case. Now, Millard, we go and Millard give him a charge sheet. Now, the language of the charge sheet is very important. Please take Millard page number 50, 50. But in the highlighted portion, I will not trouble your lordship with it in its entirety. Please take the fourth paragraph in the highlighted portion.
Yes.
In your letterhead.
Hmm.
In your letterhead, you have never disclosed your additional qualification diploma of fellowship so-and-so. To misrepresent the patients and the general public at large, you didn't mention diploma of fellowship FRCP Glasgow. As your additional qualification, you only mentioned FRCP Glasgow is your additional qualification in the letterhead. The act and actions of yours as a medical practitioner is violating Rule 26 of etc. Misrepresentation of your additional qualification amounts to an infamous conduct in professional respect. But the charge is that only saying FRCS Glasgow gives an impression to the general public that you are a degree holder. You ought to have written diploma and fellowship, then FRCS, so that the public, because he has mentioned specifically that when we go to a government hospital, we don't look into the doctor's qualification, or rather we are not in a position to ascertain. But when we go to a doctor, we try to ascertain what is his or her qualification. Now, if I go to this doctor, I may be misled that no, he is a degree holder of the Fellow of the Royal College of Physicians. Therefore, this is an additional qualification. He must be a good doctor, a better doctor, or more having more degree than any other MBBS. Now, this is the charge against him. Then please take me, Lord, his reply to it at page 52. It's primarily, my lord, the reiteration of the previous letter. Again, we are at page 54. He says,
Learned AG, please confine your submission to this as to what will be your answer to the point that has been raised that the order impugned is a non-speaking one.
Yes.
Please.
Lord,
these things are already there on record. Your authority could have passed an order by taking all these things and then pass an order.
Could I say this?
Yes, please.
Number one, Millard, he knows what is the charge against him.
He may know it.
Yes.
But then for him to go in appeal, what will be his grounds of appeal? There is an appellate forum.
Yes.
But the court
But
is
that is my point.
interfering. The court is interfering only because it happens to be a non-speaking order.
But may I say this? Number one is, a non-speaking order by itself is no ground to for interference. Why I say this? But my learned friend's client has to show prejudice. The prejudice test is what your lordships have embarked upon when somebody comes and alleges breach of natural justice.
Yes.
Therefore, my lord, my learned friend should demonstrate before the court that how is he prejudiced by the so-called non-speaking order, because he has been told that this is the charge. He accepts that he ought to have registered this. He accepts that he had applied for registration. Now, if he has applied for registration, the minimum that is required is that registration needs to be granted.
You never know whether there is a requirement of a registration or not. The court at this stage will not go into it at all.
Yes.
Thing is, you say, tell me this certificate at page 30, the date appears to be 2019.
2019.
We are in 25.
Yes.
And since when is he using this nomenclature over there?
6 years. But maybe 6 years. But today,
6 years?
Yes.
It didn't come to your knowledge?
No.
It must have come to your knowledge by way of a complaint or something. Though you say suo moto,
no complaint.
It comes to your knowledge suo moto.
Milord, your lordship, Milord, this comes because according to him, he had applied.
No, not according to him, according to you. When did it come to your knowledge?
Milord, please take, Milord, his paragraph, page number 7 at the top, or page number 6 of the writ petition, last line. Or the last 4 lines.
What is it?
For argument's sake, whatever he is saying is correct. Please take page number 6, the last 4 lines.
Page number 6. Prior to issuance.
Yes, that prior to issuance of the show cause notice, the petitioner was asked by the respondent number 2 to get the FRCP registered with the respondent number 2 as an additional qualification. Consequential to the same, the petitioner made an application on 3rd of March and the respondent herein took an amount of so and so for registration of the additional qualification. Therefore, it is his case that a registration is required.
No, but then it is also his case that he did it pursuant to the direction given by the respondent number 2.
Yes, somebody may have advised him that get it registered.
So this person is using that nomenclature since 2019 till 2025.
But if it is an infamous conduct,
yes,
then Millard, the infamous conduct continued for 6 years.
Right.
Now, please consider, Millard, this infamous continues every minute, every second.
Yes.
It continues today even.
Right.
From the documents on record, it is available that at least from 2024, my learned friend says 6 years, 6 years. Let us assume for argument's sake, Millard. Millard, the fact that he has been using it for 6 years will not, Millard, prevent me from taking any step.
Yes.
Provided he says that no, it is not an infamous conduct.
Provided,
that is not.
Provided you give him the reasons for taking these steps. Certainly, you have a right to take steps for any infamous conduct as per the act. But let the person know that what is the ground for which he can prefer an appeal before the appellate authority.
But the ground
What
is
I
easy.
intend to do,
Yes, ma'am.
let me make my mind clear, and thereafter you all can make submission.
Yes.
The issue is with regard to page 30. The letterhead of the petitioner, there is a mention of FRCP, Glasgow. Let it be mentioned as diploma of fellowship, such and such, as appearing in the certificate itself. Now, what this will go to the public, how the public is going to take it, does the general people know that there is a difference between a degree or a diploma? I do not know. As an advocate, as the Advocate General of the state, you may know that there is a difference. There may be many out here who may know, but general public, how much they will know, I do not know. There is the certificate mentions diploma of fellowship, such and such. Let he use this. You will be given permission to conduct the proceeding in terms of the act. Give him the reasons that these are the reasons. Thereafter, whatever is the order, provision for appeal is there.
But may I not only react to the
Yes, please.
in this very humble way?
Yes, please.
But the reason that I'll give is in the charge sheet itself. And
maybe there in the charge sheet, not reflected in the order sheet.
Kindly consider this, Milord. He is aware of the charge.
Maybe.
But he doesn't deny.
Please, no.
Milord, I tried to find out.
No.
I tried to find out, Milord, from
No,
the
no.
petition.
Yes.
That he has said.
He may know a lot of things. Why will it not go down in the order? It is only for this reason.
Milord, the reasons may or may not be there, Milord.
And thing is,
yes,
he is using this for 6 years. You conclude the proceeding in accordance with law at the earliest. And he is, during the period that you will conclude the proceeding, he will use whatever is there in the certificate.
But that will not do away with the wrong that he has done.
Maybe, but then you say he is using this as a qualification without registration.
I'm not saying
that. Or whatever. Now, whether please come. And what about the communication? You did not communicate the order to him.
As per the rules, Milord, it has to be gazetted. The gazette notification has been done.
All right. And no
communication. He has annexed it.
No, he has not. No communication.
Fine. Caveat page, fine.
But my instructions are that it has been dispatched.
Maybe he'll receive it.
Yes.
But then this has come prior to that. Please come.
But is your lordship's pleasure to dispose it of?
Absolutely. I'll give you the liberty to proceed.
Give me a moment to take instruction.
From whom? No, you are the all in all. No taking instruction and no consultation. I give you liberty.
No, the instruction which I would require is from which stage should I start?
What I would propose, you have given the charge sheet and a reply is there. Start it thereafter. Give him a hearing, or if the hearing is there, hearing is over.
Yes.
Hearing stage is over.
During the hearing, on the 3rd of July, they gave me questions. But the questions and the answers are appended here. No consideration thereof.
No, they'll consider in their final order. If the hearing is over, then you
can
pass
an opportunity of hearing to explain myself.
Further opportunity.
Yes, another opportunity. Because my specific stand is, this is not a degree. Whatever stand might have been taken, in the last representation, I have taken this specific stand.
In all along, in your communication, you have mentioned.
Chakraborty also, that in the initial stages of the reply, even against 9th June, the language is little different, but starting from page 67, 66, kindly sees the response.
Thereafter, the legal advice came in a different manner.
I don't think there was any legal advice.
Previously may not have been, but thereafter something has.
He has deposed before the authority.
Yes.
The committee.
Whatever is there.
There, at page 75 of the writ petition.
Written communication.
Please come.
Written questions.
Written communication, whatever. Yes.
The petitioner. has averred in the writ petition that he is a medical practitioner and he holds the degree of MBBS and DMRD and has been honored FRCP within bracket Glasgow and FIAMS. Stop. He claims that he is the secretary of the Indian Medical Association and the member of the MAC, National Medical Commission. Stop. He is aggrieved by the order dated 4th July 2025 passed by the West Bengal Medical Council, whereby he have been found guilty of infamous conduct in a professional respect. Now, conduct in his profession, and decision has been taken by the council to remove him from the register of registered medical practitioners maintained by the West Bengal Medical Council for a period of 2 years from the date of communication of the order. Stop. The learned advocate representing the petitioner submits upon instruction that the impugned order is yet to be communicated to the petitioner. Stop. The petitioner got to learn about the order from the official website of the medical council. Stop. Paragraph. The very first point of attack is that the impugned order is a non-speaking one. Stop. No grounds and or reasons have been mentioned by the authority for removing his name from the register of medical practitioners. Paragraph. It has been submitted that a show cause was given to the petitioner on 9th June 2025, which the petitioner responded on 23rd June 2025 and responded on Apple by filing a detailed answer. Stop. In the impugned order, none of the explanation given by the petitioner has been taken into consideration. Stop. Next. The nomenclature in the letterhead of the petitioner, which gives rise to the instant proceeding, mentions that the Royal College of Physicians and Surgeons of Glasgow offered the diploma of fellowship within bracket FRCP within bracket GLASG bracket close. Now offers হবে না, certifies. কি বললাম? Royal College of Physicians. To the petitioner for having acquired distinction as a physician on the 22nd day of February 2019, duly admitted a physician fellow of the Royal College of Physicians and Surgeons of Glasgow. Stop. According to the petitioner, the said diploma is merely an honor and not a regular educational qualification which the petitioner obtained. Stop. Next. It has been submitted that the petitioner is practicing on the basis of the qualification which he acquired after his regular studies. Stop. Next. On a perusal of the show cause notice, it appears that on a perusal, the show cause notice mentions that information and evidence have been laid before the council on the basis of a complaint and further inquiry on which charges have been framed against the petitioner. Stop. The petitioner alleges that neither any information, nor evidence, nor complaint, nor report of inquiry was ever furnished to the petitioner. Stop. Paragraph. It has been submitted that without the complaint or the information or the evidence or any further document relied upon by the authority to pass the impugned order has not been communicated to the petitioner. Stop. Without the details of the complaint or allegation relying upon which the impugned order has been passed, the petitioner is not in a position to defend himself properly. Paragraph. Prayer has been made to set aside the impugned order. Stop. The Learned Advocate General represents the West Bengal Medical Council. Stop. It has been submitted that the charge sheet is a detailed one and the petitioner is aware of all the charges leveled against him. Stop. It has been submitted that it is the admitted case of the petitioner that the the diploma is a qualification for which the petitioner applied for registration of the same. Stop. Next. The communications made by the petitioner in response to the show cause notice.
One thing it needs to be shown. I have said that it has been verified. That document I have craved for kindly, it is also there.
What thing?
It has been verified by the council.
Which document? Page 30? Page 50?
That page 30 is 30. Something which is genuine, or it has been verified by the council upon my making the application.
No, how does it matter?
Well, she wants to.
Because that is not the allegation. Yes. Is it say no?
It does not say.
I didn't see that it mentions fake or it is not.
No, it is not a fake.
Also mentions the said diploma as a qualification. Stuff. It has been submitted that the general public may be misguided and misdirected by observing the description of the doctor as reflected in the letterhead. Stop. It has been argued that the petitioner will in no manner be prejudiced if the reasons are not disclosed in the impugned order. Stop. Next. I have heard the submission made on behalf of both the parties. Stop. The submission of the learned Advocate General that the petitioner will not be prejudiced cannot be accepted by the court. Stop. The delinquent is certainly entitled to know the reasons for which he is being removed from the list of register of the medical practitioners. Stop. The subject qualification, the subject, the mention of the diploma is appearing in the letterhead of the petitioner for the last 6 years. That is from the date of its issue in the year 2019 till the show cause notice is issued in the year 2025. Stop. If the authority intends to prosecute the petitioner, then proper reasons ought to be mentioned in the impugned order so that the petitioner may challenge the same before the appellate authority. Stop. The impugned order discloses the appellate authority but does not disclose the grounds on which the petitioner may move the appellate forum. Stop. Paragraph. Without entering into any further details, the court is of the opinion that the impugned order is bereft of the grounds on which it has been passed, can be treated to be a non-speaking and a cryptic order and is liable to be set aside. Stop. The impugned order is accordingly set aside. Stop. The petitioner, however, is restrained from using the expression FRCP within bracket GLASG in his letterhead until further orders. Stop. It will be open for the petitioner to use the expression
Diploma of Fellowship, FRCP,
as mentioned in the subject certificate. That is Diploma of Fellowship, FRCP within bracket GLASG.
Yes. Yes.
The medical council is directed to forward to the petitioner any information, evidence, the complaint or inquiry report based on which the show cause notice and the impugned order dated 4th July 2025 has been passed, and give an opportunity to the petitioner to respond to the same. Stop.
Yes.
An opportunity of hearing shall be provided to the petitioner. Stop. A reasoned order shall be passed by the authority at the earliest. Writ petition stands disposed.
We have also questioned the charge sheet. Milord kindly keeps that question open for an. Kindly keeps that question open. But otherwise, Milord, I'll be in order to rule 2 bar.
Where?
It is. It is under.
It will be open for the petitioner to raise all issues at the time of defending the charges leveled against him. Yes, Mr. Sen.
That was the first one.
I will record that also. একটা প্যারাগ্রাফ যেখানে এজি সাবমিশনটা হচ্ছে সেখানে রেকর্ড করবেন. It has been submitted that the charges.
One is page 50.
1 minute. That the communication made to the petitioner dated 15th of May 2025 clearly records that the proceeding in question is a suo motu one. Stop. Paragraph. The aforesaid contention of the authority appears to be contrary to the charge sheet which has been issued on 9th June 2025, which clearly mentions about information, evidence, complaint and inquiry. Stop. If the proceeding is a suo motu one, then the question of any information, evidence, complaint or inquiry from outside would not have been mentioned in the charge sheet. Stop. Had it been a suo motu proceeding, then the basis of the suo motu proceeding should also have been disclosed to the petitioner for him to defend his stand.
Great.
But then, do we start the proceedings from the beginning?
No.
Because then this issue will again come.
No, you provide the information and the evidences and everything. So your suo motu proceeding gets cured.
This
Everything is
in effect,
mentioned in
Milord,
your
has
charge sheet.
the charge sheet should go and then you.
No, I won't go to
leave
that
it.
extent.
I leave it.
I won't go because
leave
your
it to you.
charge sheet has got mention about the information. Why don't you pass on the information if there is any? And if you feel, I can give you this liberty also. If you feel that there is a requirement of initiating proceeding de novo, you can do so. I can record that also.
In the event it is okay.
Achha. If the authority is of the opinion that there is a requirement of initiating the entire proceeding of fresh, the authority may do so. Stop. The authority shall take all steps strictly in accordance with the act, and by conforming to the principles of natural justice. উপরে যেখানে বলেছিলাম না যে cryptic order bereft of reasons, সেখানে ওপরে আরো উপরে বলেছে, সেখানে এক জায়গায় লিখে দেবেন violation of principle of natural justice.
Supplementary has been taken on record.
Supplementary affidavit filed in court today be taken on record.
Great.
Copy of the same handed over to the learned advocates representing the respondents. Any further thing which you would like to start afresh, de novo, in the event you feel so?
Otherwise, we'll be arguing the same thing all over again. The contradiction.
Grateful.
Yes, please.
Item number 5. Lordship, item number 5, I am on behalf of the applicant, Lordship.
Yes.
Lordship, on earlier date, Lordship, I was able to establish that the construction in question is building. Because according to section 2, subsection 3 of the West Bengal Municipal Act 1993, the construction is very much able to come within the ambit of building.
Yes.
And it is a construction. So, Lordship, after the proceeding, the writ petition was disposed of in favor of the petitioner. After that, an hearing was done. Then, Lordship, in the order sheet, Lordship, order sheet is completely briefed the direction of the Lordship. Whether the civil issue is pending or not, this is not the question. Question is that whether the sanction plan is present in favor of this construction or not. No sanction plan is present, Lordship, and in the order sheet also, regarding sanction plan, the authority concerned is very much silent in nature. The prime question is whether the sanction plan is present or not.
Please show me the portion where it says that there is no sanction. Is it mentioned?
Yes,
no,
Lordship.
The stand of the authorities, no permission is required for repairing under the West Bengal municipal rules.
Repairing, the repairing work is not done, Lordship. The question is that the sanction plan is present or not. when the construction is illegal, I'm asking myself, if the construction doesn't have the sanction plan, then this construction is illegal, unauthorized construction, illegal construction. So this construction is supposed to be removed.
Who made the construction and when was it made?
Private respondents made the construction, Lordship.
When?
The age of the construction is more or less 10 years, Lordship.
10 years.
10 years.
And
But-
private
but-
respondent is your tenant.
Private respondent is not a tenant.
Is
The father of the
co-sharer.
private respondent was a tenant, and as per this West Bengal Premises Tenancy Act, they are the tenant. The sons are the tenant of the tenant for 5 years, and after that, Lordship, suit was filed. Suit was decreed in my favor.
No, don't go to the suit.
Hmm.
The tenancy is being carried over by the son of the tenant, right? And the when was the father inducted in the in that place, in that house?
Lordship, long back.
Long back.
Long
And
back
the construction is 10 years old, more than 10 years.
Actually, at initial stage, the house was the mud house, Lordship, and after that, Lordship, it was broken by the private respondents, and construction, that means building,
construction
construction was made.
Walls have been made. It is tile shed.
Walls have been
It
made.
is still tile shed.
And Lordship, when the pakka wall is present, Lordship, so according to the definition, it is a building, it is construction.
Yes.
And sanction is required.
Right, but then the construction was made by you, or was it made by the private respondent?
Made by private respondent.
What did you do for the last 10 years when the construction was there? You filed the writ petition in 23.
23. Yes, this is the time delay, Lordship. But Lordship, repeatedly I sent the representation to the concerned municipality.
No, that is different. The writ petition is of 22, right? And the it is still tile shed.
Actually, Lordship, roof was being made, but by strength of the writ petition and by strength of your Lordship's order, presently they are not making the roof over this building. By strength of your Lordship's order.
What is the position of the decree now? Got it executed?
Execution case is pending, Lordship, and against the decree, they preferred an appeal. Due to pendency of the appeal, execution case is not proceeding.
Right.
Because one declaration was given by the plaintiff petitioner that execution is, the decree holder, that execution the case is pending. One declaration was given by the judgment debtor.
Yes.
By judgment debtor.
Right. What is your submission?
My lord,
Your affidavit says that there is no requirement of.
because they made a complaint for new construction in the premises. We inspected the premises. We found that tile shed was repaired, and thereafter
What about the walls?
Walls, well, that is a old structure. They have not made any wall 2020 or 20 after 20. This is the old structure.
The submission is that it was mud wall, and now they have.
There is no allegation in the writ petition. They have stated that 2019 they preferred suit and degree was.
The suit is different. Don't go to the suit. What about the construction?
Construction is there. When we received the complaint, we went there and found that some repairing work in respect to tile shed. No construction found there. It also appears from the picture of the structure. Now they, my lord, shelter the municipality to take demolition order because it is pending decree, my lord.
Don't go to the decree. Decree is civil right.
Civil right.
You are only considered to see whether the construction is legal or not.
But when they made, my lord, allegation, there is no construction. Only repairing or what was there. in the type sheet. Nothing well, it appears from the picture. No new construction, no. Nothing.
Is the old construction a legal one? Don't go to the new construction. Don't go to the repairing. Is the old construction a legal one?
No, without any sanction, they made it. The petitioner made it construction.
Who made is not important. Whether the construction is legal or not.
We shall demolish the construction, but the family who they are residing there in the structure, they will kindly direct them to shift another place.
Are you representing the private respondent? Then why are you taking up their cause?
If we, my lord, demolish it, my lord, the family member is residing there.
Listen, so many constructions in the other areas are being demolished. Is the corporation or the municipality taking up the stand of the persons who are staying in the unauthorized constructions as to where they will go? Is this your duty?
No, my lord.
Then why are you making this submission?
Well, after eviction, they can demolish it. After eviction, but
are you the advisor of the petitioner?
no, my lord.
Why are you advising him when he will demolish? You are not assisting. You are taking the stand of the private respondent. You are not assisting. I do not know what is the reason as to why the municipality is supporting the private respondent who is enjoying an unauthorized construction. What is it? Who has handed over the brief to you?
Well, they inducted. Well, we are not in a position to, my lord, determine it because, yes, my lord, we received the.
You are not in a position to determine as to whether the construction is legal or not.
That is no sanction plan. That is admitted. No sanction plan. That is admitted. But, my lord,
even then, the municipality will not take any steps.
Well, we received the complaint, my lord, in respect of new construction. When we find it that there is no construction, we did not, my lord, take any steps.
Learned advocate representing the municipality submits that the construction in question has been made without obtaining any permission from the municipality. Step. It is, however, being submitted that complaint was made before the municipality at this stage when repairing was being made. Stop. Paragraph. The municipality found that tile shed structure exists at the subject place and there is no requirement for obtaining permission prior to repairing. Step. Photograph of the disputed construction has been annexed to the affidavit filed by the municipality. Step. Next. The disputed construction appears to be in place for quite some time by now. Stop. The persons occupying the unauthorized construction are already suffering a decree which is under challenge before the competent forum. Stop. The petitioner, being the decree holder, is not in a position to execute the decree because of the pendency of the appeal. Stop. Paragraph. The court is of the opinion that no matter the age of the court is of the opinion that a construction remains to be an illegal one irrespective of its age. Stop. The fact that the construction is in existence for such a considerable period of time does not regularize or legalize the same. Stop. The construction remains to be an unauthorized, illegal construction. Stop. The municipality is directed to take prompt necessary steps against such unauthorized construction. Stop. Next. Has any order been passed by the municipality?
One order has been passed by the municipality.
Page. Where is the order? Reasoned order?
I have the affidavit annexing the order.
Acha. The reasoned order of the Board of Councillors dated 28th of February 2024 is set aside. Stop. The municipality is directed to revisit the issue all over again in accordance with the provisions of law. Reasonable opportunity of hearing shall be given to all necessary parties.
Lordship, already one reason opportunity was given, Lordship, of hearing, and after hearing the order was passed, Lordship.
The contempt application stands disposed of.
I'm deeply obliged, Lordship.
I'm for the petitioner. The petitioner participated in a tender for supplying of some dietary items, and he has submitted the rates which are below the market value. So the state has asked for a clarification, that is at page 16.
16.
Page 16, and
yes.
You have, I'm reading it. You have offered rates of the.
Thereafter, what happens is in 22.
They have blacklisted me.
Yes.
Without giving an opportunity of.
Where is the order of blacklisting?
Initially, kindly comes to page annexure P5, that is at page 21.
Yes.
I have written this letter to SDO as well.
Where is the order of blacklisting?
My lord, kindly comes to page. I have not received the blacklisting order. My lord, kindly comes to.
Give me, let me. Order of suppression.
Order of blacklisting.
But then did you give an opportunity of hearing to him prior to?
My lord, page 23. Another 10.
He was selected as a L1 bidder. Thereafter, in terms of the condition of the NIT, he is required to deposit the security amount and also execute an agreement with the state government within 15 days. That he didn't do. We have sent 3 reminders. One reminder has been received by him, another his wife, and third reminder.
What happened to the tender? Thereafter, it was given to a proper person. And
previously, he was blacklisted in the year 2015.
What then thereafter? The period of blacklisting must have been over.
That has been over.
Then he is continuing, and here it blacklisting for how many days?
3 years, my lord. From 9th of January 2023. Page 23 is another.
Where is the tender? Denied times of regulations. Yes, not be blacklisted. 7/12/22. 23. You're blacklisted. Why are these communications not annexed to the writ petition?
But as per my instruction, my lord, he has not received anything from the. Well, it kindly comes to page 21 of my application, my lord.
Postal receipts, I have also annexed.
Please come. The petitioner claims to be alleged by an order of blacklisting which was passed behind his back. Stop. The learned advocate representing the state respondents submits upon instruction that all communications were made to the petitioner and the petitioner was given opportunity to defend himself. Stop. The respondents are directed to file a report by way of affidavit disclosing all facts and figures by 2 weeks, 18th of July. List on 28th July. Exception to the report may be filed by the petitioner prior to the adjourned date. Do you have a copy?
Yes, I have it.
I'll keep this. Achha. Statement of facts forwarded by the subdivisional officer Bonga, North 24 Parganas, dated 6 July 2025 to the learned advocate representing the state respondents be retained with the records.
I'm great. I'm great.
Item number 7.
I am appearing on behalf of the Union of India.
Dismiss for default.
For the state estimate.
Kindly praying for not to.
Last time also, my lord, they fought for time. Nothing is there in this matter.
Who are you?
Notary.
You are the advocate on record. Please place the case. Dekhi file. What is the matter?
Lordship, I have submitted an application for the appointment of notary 2020, and I have seen in that examination, and there were some illegalities in that examination. Why?
Thereafter, please use the microphone. Turn it towards you.
There were some illegalities.
Yes.
In that examination. That's why I have sent a representation about the appointment, but my representation is not
Considered. Tell me, what are the irregularities? Was there an advertisement made?
But he has participated in the selection process. Interview was held. Lordship will kindly comes to page 14. Lordship, page 14. Lordship will find item and selection number 179. The petitioner in 2021 he participated.
Yes.
Now thereafter he has not been selected. In 2024 he made a representation. I do not know whether it has been received by the LR or not, but it should be before the judicial secretary, not before the LR. He has made that he has to be considered.
When was the result declared?
21.
21.
Yes.
Date of interview is 29th of January 21. Result has been declared in 21 itself. And the representation is filed. Yes. What is the reason for the delay? 3 years delay? Have you mentioned anything? Please come. The petitioner is aggrieved by inaction on the part of the respondent authority in taking steps to consider his representation allegedly filed, highlighting certain illegalities in the recruitment process for appointment of notaries, 2020. Paragraph. It appears that the petitioner appeared for the interview on 29th of January 2021 and he made a representation before the learned legal remembrancer in February 2024. Stop. There is no explanation as to why the petitioner sat tight from 21 till 2024 for submitting a representation before the authority. Stop. Paragraph. It is the specific stand of the state that the petitioner was unsuccessful in the recruitment process and result of which was declared in the year 2021 itself. Stop. The petitioner made a representation allegedly in February 2024. Stop. Upon hearing the parties, it appears that there is no explanation with regard to the delay on the part of the petitioner in approaching the legal remembrancer with a representation. Stop. The legal remembrancer is not a competent authority to look into the matter. Stop. The recruitment process was conducted by the which department?
The Department of Law and Justice, Government Development.
If it is law and justice, then legal remembrancer can take it.
Joint ticket fee.
Acha.
Miller, instruction was given to us is OSD and EO Joint Secretary. I believe Joint Secretary of Judicial Department.
Then it has gone to the right person. Acha, legal remembrancer is not the ki bollam? By the Secretary of the Judicial Department. Stop. Next. The delay in filing the representation before the authority is absolutely fatal in the instant case. In view of the above, no relief can be granted to the petitioner. Stop. The writ petition fails and is hereby dismissed.
Yes.
Next.
Hey, Lord.
My lord, made by Mr. Shubhitra Panda and submitted.
Yes.
I'm there, my lord, online, my lord. I'm
all right.
Paricha, my lord.
All right, all right.
My lord, I made an application for added as a respondent. Petitioners filed this application. My interest.
Please use the microphone. Somebody is there online.
Petitioner is filing this application, my lord, suppressing the entire fact that one order was passed by Honorable Justice Sabyasachi Bhattacharya. That order was challenged before the Honorable Division Bench. Honorable Division Bench also passed on, my lord. My lord, kindly consider my application.
All right, let me hear once what the petitioner says. I'll hear you. What is it? It's issue, 1 minute. It relates to issuance of notification of appointment of MMR in Kalitala Ashoti Police Station. Secretary is directed to take steps and file a report. WPA 21885 Habibullah Khan. Are you Habibullah Khan?
Yes, madam.
All right.
My lord,
Yes.
we have my junior would be filing the report, my lord.
Yes, yes. Report is there before the court. What is your case?
We have also received the report, my lord, though belatedly, but we've received it on Friday, my lord.
Yes.
But after going through the report and, my lord, the CAN application filed by my learned friend, my lord, there are several orders that I see, my lord, which have been passed from time to time in respect of the same post, my lord, which, my lord, one, my lord, Habibullah, which my learned friend is representing, wants to be appointed as. Apart from Habibullah, my lord, there's one more candidate whose name is, my lord, Musibul.
All right.
He also wants to be, my lord,
appointed in the same place. Yes.
Apart from the other two, my lord, I am the third candidate, my lord. We are all fighting for the same post. Now, my lord, very briefly, if I can take your lordship, my lord, through whatever has happened till date, my lord, which I could gather from the two pleadings, my lord, the report and the CAN, my lord. My lord, I had filed the writ petition, my lord, whereas, my lord, one of the prayer was, my lord, that the order dated 9th of January 2023, my lord, be acted upon, my lord, which was an order passed by Justice Bhattacharya, my lord, wherein he had directed, my lord, for appointment of an MMR under the particular police station, which is Kalitala Ashoti Police Station. Apart from that, my lord, he had also directed for consideration of the representation of Habibullah. So this order was challenged by the state by filing FMA 285 of 2023.
Yes.
FMA 285 of 2023, my lord, if your lordship sees, my lord, in that I could gather.
Where is the order of the Honorable Division Bench?
Well, they have
annexed.
No,
have you annexed it in your?
Yes, my lord.
Yes. Where is the CAN? Which page?
My lord, page 10, my lord.
Page 10. Yes.
As my lord, there was
1 minute. I can read it.
Kindly comes to page 12, paragraph 4 is the operative portion, my lord.
Yes.
So in paragraph 4, my lord, if your lordship has seen, my lord,
my lord,
a
next page.
direction was given, my lord, for my lord, creating the post, and my lord, the direction with regard to consideration of his representation, my lord, was set aside. Thereafter, my lord, the state, my lord, in terms of this order passed in FA, my lord, the state created a post, my lord, under this particular police station, my lord, which your lordship will find at page 8 of the report filed by my lord, the state.
My lord, next page, my
I'm taking
application,
your
page
lordship,
14, my
I'm
lord.
taking your lordship
Page
sequentially, my lord.
14 post was created.
I'm
1
taking your
minute,
lordship sequentially.
let me, yes. 12th of September 23.
12th of
It is
September
there.
2023, my lord, this
Hmm.
post was created.
Page 15,
Thereafter, my
my
lord,
lord.
Yes, then.
thereafter, my lord, WPA 27415 of 2023 was filed by my learned friend's client Habibullah, my lord, which, my lord, was disposed of on 5th of February 2024, my lord, with a direction, my lord, to, my lord, act in terms of Rule 9, my lord, which again is for appointment, my lord, of my lord, the MMR.
Has
My
any MMR been appointed?
No, my lord, not yet, my lord. Approval is there. There is no license.
Yes, my lord.
Then, my lord, may I,
My lord, Moheshtola MMR is working as an additional charge, my lord.
9/6 of 2023 was filed by Mosibul, my lord. Mosibul is the one, my lord, who's contesting against Habibullah, my lord. In his application, my lord, again a direction was passed on 5th of March 2024, my lord, to take a final decision, my lord. In terms of this order, my lord, on 10th of May 2024, an order was passed, my lord, in my lord, and my lord, the proposal of Habibullah, my lord, my learned friend's client, my lord, was considered and the proposal was allowed. And my lord, the proposal of, my lord, because he is not asking for appointment, he is asking for transfer. He is already operating as an MMR under Moheshtola, he under Survey Park. He wants to be transferred to my lord, Khalidul Ashuti. So his application was allowed and the application of Mosibul was rejected. My lord, challenging the order of 10th of May 2024, Mosibul again filed 14573 of 2024, my lord, in which, lord, an order was passed on 24th of May 2024. Lord, this is the order, my lord, which my learned friend, my lord, I wouldn't say suppressed, my lord, maybe he must have missed. But this is a very important order, my lord. If your lordship kindly comes to paragraph 19 and 20.
Yes.
Paragraph 19 and 20, if your lordship sees, my lord, this
stay of operation.
Yes, stay of operation of the order.
Hmm.
So because of this order, my lord, what I could gather from the report filed by the state, my lord, one Khadija Khatun, which your lordship will find at page 13 of the report filed by the state. One Khadija Khatun, my lord, who is already, my lord, officiating as an MMR under Moheshtola, has been given additional charge to perform as an MMR under, my lord, this particular police station, my lord.
Pursuant to court order.
The order which was passed, my lord, 24th of May 2024, in, my lord, challenging the order date 10th of May, this writ petition was dismissed for default on 10th of June 2025, which, my lord, my learned friend has annexed.
Yes.
So this has now been dismissed for default, and my lord, all interim orders, my lord, vacated. And from the order, my lord, report filed by the state, I could gather that Mosibul has already filed a CAN, my lord, CAN 1 of 2025, my lord, which is for restoration, which the state says is pending consideration before this honorable court.
Please come.
So this being, my lord, the entire gamut, my lord.
The matter relates to appointment of temporary marriage, Mohammedan marriage registrar within bracket MMR for the newly created Kalitola Ashuti police station. Paragraph. It appears that the state is yet to take a decision with regard to appointment Stop. The issue in question is was pending consideration before the court in WPA 14573 of 2024 within bracket Sheikh Mosibul Hassan versus the state of West Bengal and others, which stood dismissed for default by the court on 10th June 2025, and it is reported that an application for restoration is pending consideration. Stop paragraph. As there is no legal bar on the part of the authority to take steps to fill up the post in question, accordingly, the authority shall take steps in the matter in accordance with law. At the earliest, stop. Report in the form of affidavit filed on behalf of the respondent number 2 be written with the records.
My lord, kindly consider
Let
this
the best,
24, my lord.
let
Yes.
the best
I
candidate.
was-
The connecting application also stands disposed.
My lord, I-
By dispose means allow him and then disposed.
My lord, in my application, I have annexed the document that I was appointed already, my lord.
Yes, the authority will consider.
Authority already appointed me.
No.
Even thereafter, that was under challenge. The order was temporarily stayed, and now the writ petition stood dismissed.
Dismissed.
Now, what the authority will do, let the authority take steps.
May I, my lord, very humbly, my lord, very respectfully say this, my lord. My lord, let the best candidate, my lord, be appointed at this for this post, my lord. If your lordship may kindly, my lordship has directed the authority to take steps, my lord. My lord, take steps, my lord, in accordance with law after hearing, my lord, all the three candidates.
I am not passing any order
Whoever
for
is the
hearing.
best candidate,
Yes.
let the best candidate be appointed.
You think the authority is going to appoint somebody who's less than the best?
I'm grateful, madam. I'm grateful.
But I appear on behalf of the writ petitioner.
Yes.
I appear on behalf of the state, Your Lordship.
Immediate concern, my lord, we have filed and can application for an order that was passed by the appellate tribunal under the PMLA Act. My lord, the writ petitioner before your lordship is the tenant in respect of a 6 bighas of land. It is a 216 or 214 decimal of land at joint industrial complex at Howrah, Domjur. My lord, the landlord, our landlord, my lord, took loan from the SBI. It's about 259 crores and etc.
Who is representing the Enforcement Directorate? You are for whom?
Lordship, I beg to appear on behalf of
State. The State Bank of India is there.
Lordship, I'm appearing on behalf of the respondent number
There
10
are other
11.
authorities also. RCIL is there.
I presume, Your Lordship, there is someone who is appearing online.
My lord, we have served all
Lordship,
of
am I audible, Lordship? Lordship.
the affidavit of service with respect
Respond
to
number 10 and 11.
All right, the State Bank is there.
these are the affidavit of service with respect to writ
Yes.
petition, and here is the can, my lord.
All right.
Lord, the
What is your
immediate-
prayer?
Immediate concern, my lord, at page 18 of your lordship's brief, that is can. That's the affidavit of service. My lord, if your lordship
Can.
kindly takes up the can, my lord,
Page 18.
page 18 of the can, my lord.
Yes.
My lord, here the appellate tribunal of the PMLA Act, my lord, the order has been passed. If your lordship, have your lordship got it, my lord?
Yes.
My lord, the adjudicating authority passed an order. Initially, a preliminary order of attachment was there. Thereafter, adjudicating authority confirmed that attachment order. And thereafter, appellant, my landlord, preferred an appeal. And the appellate order was passed, which was subsequently the filing of the writ petition. My lord, there, my lord, appellate authority ordered, if your lordship kindly come to paragraph 6 of the order, my lord.
Page 20, the can application.
Yes.
My lord, it is made clear that this order meant the appellate order and the adjudicating authority's order for confirmations of attachment, my lord, would not be taken adverse to the appellant. My lord, the appellant admittedly created a tenancy in my favor in the year 2013. And thereafter notice was served under 13.2 in the year 2016. State Bank of India issued. My lord, there is a loan transaction between the bank and my landlord. My lord, my immediate concern is this: my tenancy should not be disturbed. My tenancy should be protected. I am guided by the authority of Supreme Court, my lord, and they have in different judgments, it has been settled principle that if the tenancy has been created prior to the notice, my lord, then the tenancy survive the surfacey action or the PMLA action. My lord, here 2 actions has been initiated by the bank, my lord. That's why I have come before your lordships for the interim protections. My lord, what happened in the meantime, my lord, before they pass this appellate order and after this order, my lord, the bank are continuously disturbing with their loan recovery agent and etc. and threatening our dispositions. We just protections, praying for the protection, interim protections, till the the landlord is penalized or whatever disputes between the bank and the landlord. Our tenancy should be protected. That's the interim order, my lord, that may be passed. And it has been stated in the appellate authority and also in the adjudicating authority that the
Which portion of the order did you read out? 22nd of April 2024.
at page 20, paragraph 6, my lord.
Page 20.
Of the petition.
Of the can, my lord.
Can, page 20.
This is the appellate tribunal which passed the appeal
Page
paper.
15 is also the appellate tribunal's order.
My lord, that's perhaps a repetition, my lord.
Kindly,
22nd of April 24, and this is third.
that
After
is-
final
that-
order, what is the order that can be passed?
my lord, the page 18 is the immediate concern. It's a order of 3rd March 2025. The appeal prepared by the appellant, that is the landlord of mine. There is a final order. The bank's borrower.
Who is your landlord?
Landlord is some Agarwal.
Gopal Kumar Agarwal,
Yes, ma'am.
Brahmanand Agarwal,
Yes.
Banwari Lal Agarwal,
They-
Kamla Agarwal.
Yes, they are the appellant, my lord. They are the borrower to the bank. And there
Who
is
is
a
this Sri Mahalakshmi?
Sri Mahalakshmi, my lord, these Agarwal's company.
And Mangalam is also Agarwal's company.
Lordship. And this Sri Mahalakshmi created tenancy in my favor. There is an agreement of
When?
my lord, in the year 2013.
All right.
My lord, that agreement
And loan
for
was taken
tenancy-
when?
Lordship,
Loan was taken.
loan was taken prior to that, my lord, perhaps, but this notice under section 13(2) was issued in the year 2016. And not only that, my lord, they have taken possession of the particular land, my lord, mortgage
Symbolic
land,
possession.
with the tenancy. The 8(1) rule 8(1) notice has been stated categorically that they are taking possessions
But then
with.
why are you here and not before the tribunal?
My lord,
Debts
tribunal
recovery
is the
tribunal.
two limb of actions, my lord, they have initiated. The bank have initiated two actions. One is under PMLA Act, another is under Surfacey Act.
Yes, you are concerned with surfacey.
My lord, we are immediately because we have been paying rent to the State Bank of India. They
All
have
right.
accepted my tenancy. That is not a problem at all.
Yes.
Because we cannot approach the surfacey against the bank by saying that I have been troubled by them.
Why not?
My lord, because of this, my lord, we have retained the tenancy possession and have been paying the rent to the bank regularly.
So what?
Now the
Your status as a tenant remains.
yes.
If you are aggrieved by any action taken by the bank for recovery of the due amount,
That is not that has not been recorded. Only because the bank together with their recovery agency, they came to my factory premises and starting disturbance. I filed a police complaint. And I do not know whether they have taken any section 14 order or something like this. Let them file an affidavit by a report by form of an affidavit. In the meantime, I may be protected. They should not raise any sort of disturbance to my factory. I do not know anything about this. Otherwise, Rule 17 4A is there for deciding
the bank.
The Lordship, at the outset, with subject to Lordship approval, the instant writ petition is not maintainable, Lordship, inasmuch as the petitioner has already filed a civil suit in Havla Court, paragraph number 15.
Regarding what?
For declaration and injunction
Of
tenancy right.
tenancy?
Of tenancy. Of tenancy. Lordship, paragraph number 15. Admittedly, they have filed. They cannot choose a forum shopping.
No.
Civil,
listen, civil suit is only for declaration of tenancy. Surfacey proceeding cannot be a subject
Lordship,
matter
so
of
far
a
as
civil
surfacey
suit.
proceeding, your Lordship knows, Lordship, that in terms of section 17 of the Surfacey Act, any person aggrieved by any action of the bank.
Are you taking steps under the Surfacey Act?
Lordship, I have my instruction is also that the company was in liquidation. The liquidation process was going on, and the property is the common pool of the liquidation.
That fall from your Lordship.
Please tell me, are you taking steps under the Surfacey Act for recovery of the dues?
Lordship, the bank has issued 13(4).
Where is that 13(4) notice?
Possession notice. Lordship, they have also annexed in the writ petition itself.
Yes, please.
Writ petition itself, they have attached the copy of possession notice issued by the bank.
Lord, I have annexed the 13(4)D. That is at page 53 of the writ petition.
Lordship, possession notice, page 62.
Yes. And that possession notice, they have stated that I am taking possession with tenant. And I have been paying rent to State Bank of India.
That does not recognize his tenancy. In terms of the provisions,
my possessions has been retained. How can I?
That's a disputed question of fact pending before the civil suit.
Possession notice has been attached.
Then
They are
against
seeking
Agarwal. Yes,
restraining the bank to take possession under the Surfacey Act. One enforcement directorate attachment is there.
Directory of habitats. On the
Page 53 is the 13(4)D notice.
13(4)D notice. My lord, here
Right.
bank asked for payment.
What is-
Wait a minute. Surfacey Act. Surfacey Act are just like there.
Yes. 13(2) issued thereafter.
13(2) issue, thereafter 13.
Possession notice issued, page 62, your lordship.
Page has covered, right? Now, section 17 becomes open to you. Where is the difficulty?
Any person aggrieved, your lordship. Section 17.
My lord, kindly consider this 13(4)D once, my lord.
Yes, please.
But fourth starts with what, my lord? In case the borrower fails to discharge his liability in full within the period specified in subsection 2, the secured creditor may take recourse to one or more of the following measures to recover his secured debt, namely, if your lordship kindly skip this then and come to D directly, require at any time by notice in writing any person who has acquired any of the secured assets from the borrower and from whom any money is due or any and may become due to the borrower to pay the secured creditor to, my lord, they have served the notice to us. And I have been paying rent to the landlord.
Paying rent does not mean liquidation of the dues.
I'm not supposed to pay the dues of 259 crores.
This is the language.
The landlord is there against them. My lord, the rent I have been paying to the landlord, my lord, that now I have been paying to the bank.
So what?
I have retained my possessions.
Yes,
And
yes,
how
please
can
come.
How can I go
The
against the
petitioner
bank?
is aggrieved by the steps taken by the State Bank of India to recover the secured loan. Paragraph. Learned advocate for the petitioner stresses on the fact that the petitioner is a tenant of the secured asset and the petitioner is neither the borrower nor the guarantor. Stop. It has been submitted that after notice was issued under section 13 within bracket 4 within bracket small d, comma, the petitioner started paying rent to the bank and the bank is accepting the rent from the petitioner. Stop. The petitioner seeks for a direction upon the bank not to take any further steps for removing or ousting the petitioner from the secured asset. Stop. It has been submitted that it is not the responsibility of the petitioner to pay off the loan taken by the borrower. Stop. Paragraph. From the documents annexed to the writ petition, it appears that, admittedly, notice under section 13 within bracket 4 within bracket small d of the Act was issued to the borrowers way back in 2018.
No, it is not issued to the borrower, my lord. It is issued to the tenants. It is issued to the tenants, my lord. That notice.
Issued to the petitioners.
Yes, petitioners.
Way back in 2018. Stop. If the petitioners are at all aggrieved by the steps taken by the secured creditor to recover the loan amount, comma, the petitioner ought to take steps under the provisions of the Act to approach the Debts Recovery Tribunal for relief. Stop. It will not be proper at such a delayed point of time to interfere with the proceeding initiated by the bank under the Act to recover the due amount. Stop. Next, in view of the above, no relief can be granted to the petitioners in the instant case. The writ petition fails and is hereby dismissed. Stop. It is made clear that dismissal of the writ petition will, however, not stand in the way of the petitioners to approach the statutory forum for relief in accordance with law, if so advised.
Well, let's say since opposition has not been called for allegation or not.
The writ petition is being dismissed, and even then you want that to be recorded.
Well, let's say I will leave it to you. Let's say I leave it to you.
Why make this submission?
Let's obliged.
Application cannot.
Even when I am for the petitioner, but Kushal Chatterjee last occasion started his submission. So kindly pass over is the matter for some time.
Why pass over? Who is your other side?
He is engaged in courtroom number 10.
Yes.
Just for 10 minutes, my lord.
Pass over?
Yes.
All right, call him. Call the next one. Who are you representing?
Union of India, Lordship.
Are you the answering respondent?
No, Lordship.
It is also served.
Who is the answering respondent?
Insurance company.
Insurance company. Anybody representing?
It is served upon them.
Insurance company, did you serve?
Yes, my lord. State.
No, state is not the insurance company. Insurance company is a different authority. Check up. Give a phone call to your learned friend who's appearing for the insurance company. Come back. I'm passing it over for the time being.
Willful, I am appearing for the petitioner.
Yes, please.
We took loan from the financial corporation and thereafter.
Lord, I appear for the respondent financial corporation, Lord.
Petitioner became ill, my lord, and business collapse. We have prayed for settlement. Settlement is going on, my lord. I am praying 2 weeks time for settlement, my lord. It is going on.
Financial corporation, you are there?
My lord, I am there, my lord. As per my instructions, my lord, the 20th March letter, my lord, which is the subject matter of challenge, my lord, though we are specified a time therein, but if the petitioner is still willing to settle, we are ready to allow 2 weeks time, my lord. If he can deposit that money, we are ready to go ahead with this.
Are you aware of any talks of settlement going on between the parties? No.
My lord, I am informed that there were some talks of settlement, my lord, but recently, my lord, I have yet to take instructions on that. But my instructions are that if he is ready to pay that money,
representing the petitioner submits upon instruction that talks of settlement are going on in between the parties. Stop. Adjournment has been sought for. Stop. In view of such submission, release the matter in the combined list of August.
Grateful.
Next. Respondent naam level.
Number 13, I am pray for not this week, my lord. Check Anwar Ali petitioner, and he has not come to due to illness, my lord. Check Anwar Ali. Aged about
For the state, Lord.
State. What is the issue?
Tender matter.
Tender. Dekhi file.
আমার নামে মিলন কোন আইতাম আমার হাত কাটে তো এখানে
When will the council come? When will the council come?
He has not come today, ma'am.
When will he come?
1 week due to inland matter, he has not come today.
The matter is pending for more than a year. The court is not inclined to adjourn.
I do not know, my lord.
Accommodation has been sought for on behalf of the learned advocate for the petitioner. Stop. Release the matter on 14th July. I'm making it clear. In case he's not there, I'm going to dismiss the matter. And character line likhe din to. It is made clear that no further adjournment will be granted. Next.
For the petitioner led by Mr. Raghunath Chakraborty, as I heard that it has not been serviced yet.
Life Insurance Corporation of India.
I'm not also in this matter. I'm not to record also.
Private respondent.
Where is the advocate on record? Where is Tapati Sarkar?
Council brief lordship, that is.
Where is Tapati Sarkar? Where is Mr. Chakraborty?
Court number 759.
Call him. In case he's not there, I'm going to dismiss it. Please call him.
Yes, Lord.
That's over.
$15 I am paying for the petitioner.
Yes.
Malad the petitioner file these.
Reserve Bank of India.
Malad already they obtained DM's order and that was
Executed.
The DM order. Malad I already filed before the DRT that is pending.
All right,
Became
please come.
infructuous.
In view of the subsequent steps taken by the bank to recover the loan amount, the petitioner has already approached the Debts Recovery Tribunal for relief. Stuff. In view of the above, there is no requirement of proceeding with the writ petition any further. Stuff. The writ petition stands dismissed as being infructuous.
Great.
With 16, the writ petition has become infructuous.
Very well. Learned advocate for the petitioner submits that the writ petition has become infructuous due to efflux of time. Stop. In view of such submission, the writ petition stands dismissed.
I appeal for Union of India having led by Mr. Kollan Chokro.
It is your name that will go down.
But in this writ petition, a so-called notice was challenged
I
subsequently.
do not want to know. 17.
Lordship, I beg to appear on behalf of the respondent's bank, Lordship. But I have
Bank?
Yes,
Punjab National Bank?
Punjab National Bank, Lordship.
Yes.
Only 17. Lordship,
17.
only 17, my lord. I am appealing for the petition, my lord. Today I have been briefed, my lord. Today morning only, my lord.
I am dismissing the
My
matter.
lord, only 2 days, my lord.
No.
Accommodation for the two days, my lord. My lord, I
More
beseech you,
than a
lordship.
year is the matter is
My lord,
pending.
it is a
Why will
change,
it be?
my lord. Today,
That is not the concern of the litigant,
my lord,
not the court.
my lord, I bow down before your lordship. Your lordship kindly accommodate me for 2 days, my lord. At least for 2 days.
What is your submission?
Lordship, only prayer is that, Lordship, I have been instructed to appear on behalf of the bank, but Lordship, no petition copy has been, Lordship, I have received. Lordship, they may be serve me a copy,
Why?
Lordship.
The copy has been served
Lordship,
on the
that
bank.
Lordship, that, but it is instructed that they have not received. They somehow came to know that this petition has been filed against.
Somehow came to know.
Lordship, that is the instruction, Lordship. May kindly, Lordship, I will take it at my own cost, Lordship.
Take it. Accommodation has been sought for on behalf of the petitioners. Stop. Release the matter on 14th, next Monday.
May kindly
Please come back.
Copy that I will maybe get. My lord,
Take it from you.
It's my lord.
Why?
My lord, 14th I have some 10 preoccupations, my lord. That
Pre-occupation on 14th.
my lord.
It will appear in the list on the 10th of July.
10th of July. My lord.
Give a copy to your learned friend. Yes. 18.
Lordship, I appear on behalf of respondent numbers 1 and 2.
Lordship, I appear for the Reserve Bank of India.
Dismiss for default, record appearance of the respondents.
My lord, I am for the petitioner in item number 18 in this case. My senior is on the way.
Please button your coat. Button your coat. Yes. What is it?
My lord, I am for the petitioners in item number 18. So my senior is just on the way.
I cannot hear you.
My senior is on the way, my lord.
Lordship, she is pleading for item number 18. Item 19 was called now.
Item 18. Item 18 has been dismissed for default. What? Yes. Who is your learned counsel? What is the name of the counsel?
Amit Kumar Kejriwal.
Where is he?
My lord, he is on the way, my lord.
On the way from where?
Senior is on the way, my lord.
From where is he coming?
My lord, I am not having the idea, my lord, but
You do not know from where your senior is coming.
no, my lord, she's
On
coming
the
from
last
the
occasion
chamber, my
also,
lord.
your lordship,
They had sought time.
the matter was dismissed for default, but later the
It was restored,
No, my lord,
mentioned and restored.
she's coming from the chamber, my lord. She's just on the way. I called her. She's just on the way, my lord.
Item 18, pass over, Akunta. Somebody was there. Somebody else was there. Item 18.
18, your lordship, I appear on behalf of respondent 1 and 2.
1 and 2. Please wait. All right, call 19.
Your Lordship, Samrita Pandey is appearing for petition in this matter, Your Lordship, due to some urgent medical urgency, Your Lordship. She has not come to court today, Your Lordship. I am praying that the matter could be taken up tomorrow, Your Lordship.
What is the matter about?
Matter is not an order of the National Commission for Scheduled Caste has been challenged by the railway. This is a fight.
Railway.
This is a fight between the two.
Yes, I see. Union of India challenging the National Commission of Scheduled.
Situation for me also.
Then?
This is a fight between two part of the government.
Same government.
May I, your lordship, can you give me 7 days time? Let me have a talk with them. Can you
Very well. Accommodation has been sought for on behalf of the learned advocate representing the Union of India, being the writ petitioner in the instant case. Stuff. Learned advocate representing the National Commission of Scheduled Castes.
National Commission for
Seek time to take instruction. Stuff. List on 14th.
Deeply obliged.
20.
For the petitioner. I beg to appear for the petitioner on the last occasion, your lordship directed to serve the state. But we cannot find the any established contact with the state advocates. And we
Are you there for the state? You cannot establish contact with
Yes,
the
your
learned
lordship.
advocate.
The phone is answering switched off for
Since when?
For past 3-4 days.
Where from did you get the phone number?
For the government pleader's office.
From the government pleader's office?
Yes, your lordship.
The Mr. Shamanto, please see if the phone number of the council has changed or not.
No longer in panel.
It's no longer in the panel.
Then we will serve fresh.
Kindly direct for fresh service so that a new man can be appointed.
What is your grievance?
But it is the appointment, the register has been, bank has been freezed of the college, which is also a trust. And so the petitioner, being the college authorities, have made a representation for the defreeze of the bank accounts, so that they can disburse the salary of the staff and also the.
Where is the order? Freezing order.
Page P2, page 11. It is the representation. And another P1 is the order.
Please come. It has been brought to the notice of the court that the learned advocate representing the state respondents, the learned advocate to whom the brief was allotted for representing the state respondents, is no longer in the panel. Stop. Let fresh notice be served in the office of the learned government pleader. Released on 14th July. Stop. Learned advocate representing the state shall take instruction with regard to pages 11 and 12 of the writ petition. Disposed 14th. Yes, next.
Now the state respondent. नामটা দিয়ে দাও petitioner তো নেই
Petitioner is not there. Dismissed. Record appearance.
Let this report be kept to the record.
Yes, report. রিপোর্ট টেকেন অন রেকর্ড। দেখে নেবেন কে ফাইল করেছে, ডেট কি আছে। নেক্সট।
Lordship, I appear for the union. Lordship, my instructions in this matter have not come, Your Lordship. We are awaiting.
Let me hear.
For the petitioner, but
What is it?
petitioner renewal of passport application has not been accepted.
Not been accepted. Your application for renewal.
Accepted, but police report has not been cleared.
So what will the authority do? If you do not have a clear police report, you don't have it. How many criminal cases are pending against you?
Only one case, my lord. The case has been acquittal. I have the certified copy, my lord.
When?
My lord, acquittal on my lord 2024 February, my lord.
When did you apply?
Applied, my lord, December 2023.
All right.
Lordship, I'm led by the learned additional solicitor general. Your Lordship, he was unwell, so he's not here today.
Show me the service upon the state, the officer in charge.
Officer in charge.
Did you serve the state?
Service has.
Please come. The petitioner's application for renewal of passport is pending consideration. Stop. The petitioner was impleaded in a criminal proceeding, which, comma, according to the petitioner, comma, stood disposed of by acquitting him. Stop. The petitioner submits that the police report has not been forwarded till date. Stop. Paragraph. Let copy of the writ petition be served in the office of the government pleader. Stop. Learned advocate representing the state respondent shall obtain instruction with regard to the police report in respect of the petitioner. Paragraph. Learned advocate representing the Union of India shall take instruction as to why the application of the petitioner for renewal of permit, application for renewal of the petitioner's passport has not been disposed of till date. Next Monday, 14th.
Deeply obliged.
Lordship, I am appearing on behalf of the petitioner, Your Lordship.
Yes.
Lordship, the matter pertains to the petitioner being one of the trustees in the trust. The trust that was formed was solely for the purpose of maintaining one deity along with deity.
What is that?
Deity.
Oh, deity, yes.
And along with that, running a vocational training center for unprivileged children.
All right.
Thereafter, a subsequent trust deed was created where the petitioner was kicked out, and thereafter, in connivance with private respondent number 7, they have now taken possession and are running illegal activities within the said trust premises.
All right.
So, in that respect, Your Lordship, we are only praying that the vocational training center be restored to its original form.
But do you have any authority because you are no longer the trustee?
Lordship, I was kicked out. The petitioner was kicked out on the ground without any.
Whatever may be the reason, but since you are no longer in.
Lordship, multiple trust deeds cannot be maintained against the same property without the cancellation.
So you approach the competent
Lordship,
authority.
we have already approached the civil court, and
Then,
civil suit is pending, Your Lordship.
Yes.
But momentarily, I'm only seeking relief on the ground that the vocational training center be restored, Lordship.
How can it be at your instance? What is your right to that trust? Right now, you are nobody. You are as good as a stranger to the trust.
But Lordship, that is under dispute and that is under challenge.
Obtain order from the civil court.
Lordship, that is under under challenge, Your Lordship. But
if you want a interim order, temporary order, you get it from the civil court. How can the writ court enter into all these things? Because you admittedly say that.
Lordship, I'm covered by 2 judgments of the Supreme Court, if I may be allowed to place.
No, on which ground?
Lordship,
what is the issue?
That even if it's private dispute, we are entitled, mandamus can be granted on the authorities to restore.
Sorry, sir. I do not think that judgment can help you over here because I see there is no dispute between you, legal dispute, which this court or the authority can resolve.
But the premises that is being used, that was the trust
premises.
Yes, that is being used for illegal purposes. So the writ court can intervene into the matter, Your Lordship.
Well, may I, my lord?
Only on that context.
No, sorry.
Well, there are other two writ petitions pending on that score.
Number?
6860 of 2023.
Is it appearing in the list?
One is appearing. 18511 to 2023.
Item number?
Item number I don't have, my lord. I have the WPA number.
All right, item number. Is it there in this list only?
One in the month list, one is not in the list.
One is, give the numbers. Are you aware of any two writ petitions in respect of the same trust? Not the others?
There are matters.
Other two matters. Give the number.
WPA 6868
Please
of 2023 on the same issue.
The instant writ petition revolves around a trust property. Stop. Though the petitioner claims that he was one of the members of the trustees at one point of time, but currently he has been illegally thrown out from the said board of trustees.
Same prayer there also.
Right. He prays for a direction upon the respondent authority to inquire into the illegal activities conducted by the trust. Paragraph. Learned advocate representing the state respondent submits upon instruction that two other writ petitions in respect of the same trust is pending consideration before the court. Stop. Give the numbers. Let writ petition numbers such and such appear in the list on 14 July. You will take the numbers and inquire.
I will, Your Lordship.
Right? মামলাগুলো কোথায় আছে সেটা দেখে নেবেন. On 14th July, let it appear. Let's see.
I'm grateful, Your Lordship.
Let notice be served upon all the parties in respect of the three writ petitions. Here also private respondents are there.
They are the writ petitions there.
I understand.
I'm grateful.
Next.
Matter, Mr. Abhitav Ghosh is appearing on behalf of the writ petitioner. I'm paying for not to tell.
Why?
But he's in another court.
Is in another court?
Yes.
I'll pass it over. Let him come. If he doesn't come, I'll dismiss it for default.
But
call him. 25.
I'm for the petitioner.
Yes. Yes. What is the matter? Keep it there. Keep it there. What is the matter?
The father of the petitioner is now more than 70 years old, and he was an ex-employee of Water Wing Civil Defense of West Bengal. Now, at present, he is suffering from the several disease and serious disorder, serious mental disorder and psychiatric disorder. He is unable to sign, and now the problem is that the petitioner is unable to withdraw from from his father's account.
Why will the petitioner withdraw from his father's account?
The petitioner is unable to sign in the check and due to maintain the.
So you have to contact the bank. What is the stand of the bank?
It says that without the order of the court, we cannot allow to withdraw any amount from his account. Kindly come to the page number 22. We have made the representation, but they did not pay any heed.
He is suffering from mental disability, and a legal guardian is to be appointed. So you obtain orders from the civil court regard to the legal guardianship. What will the writ court do over here? The court cannot pass any order upon the any XYZ to handle operation of the petitioner's bank account.
But without the court order, the petition is.
Court does not mean the writ court. Court means the competent court. You have to go to the civil court to obtain an order. Where is your other side?
I have served.
State Bank of India, is anybody appearing? Let me see the service. Acha, please come. None appears on behalf of the State Bank of India. Stop. Let further notice be.
Let them come.
Let further notice be served. Stop. Release the matter on 14th. Yes, next.
May it please your lordship. Lordship, the petitioner is presently unwell. And we are unable to take any necessary instructions from him. So pray for a short adjournment, your lordship.
Learned advocate for the petitioner submits that the petitioner is unwell, for which necessary instruction cannot be obtained. Stop. Accommodation has been sought for. Stop. List in the monthly list of August. Next.
Lordship, I am for the petitioner. In this matter, your lordship, it's a change brief, your lordship. The erstwhile advocate has misplaced the brief, your lordship, along with the service. I am in a very difficult situation, your lordship. My humble prayer before your lordship to kindly permit me to take out a certified copy of the petition, and your lordship kindly direct me to serve it afresh upon the respondents, your lordship. It's my humble prayer.
Where is the no objection from the earlier advocate?
Lordship, I have it. I have sent my clerk to file it before the department, your lordship.
The matter was filed more than 1 year back.
Yes, your lordship, I understand.
Today, when it is taken up, you say that the advocate has lost the brief.
Lordship, this is my instruction, your lordship.
Who has given you the instruction?
Lordship, the insurance company. I am representing.
Insurance company?
Yes, your lordship. The petitioner is the insurance company, your lordship.
That means you got it from the petitioner? You got the instruction from the petitioner?
Yes, your lordship.
And your grievance is against the?
Lordship, I do not have the brief, but it should be against the order of the insurance ombudsman.
Are you aware whether the writ petition has been served or not?
The affidavit of service could not also be provided to me, your lordship.
Learned advocate representing the petitioner seeks adjournment. Stop. It has been submitted that the writ petition has been misplaced and the petitioner intends to obtain a certified copy of the same. Stop. Let the file be sent down to the department. Stop. Release the matter in the monthly list of August.
Lordship, direction be given to serve it afresh upon the respondent, your lordship.
Let service be effected upon all the respondents prior to the adjourned date.
And lordship, in item number 29, your lordship.
We are in 27.
Great.
Should I beg to appear under the petitioner? This affidavit.
Yes, what is your prayer?
Lordship, petitioner's residential house, lordship, and which from where he is living for the last 40 years. It's an ancestral property. Lordship, in front of the ancestral property, that is the residential house or plot, there is the PWD land, lordship, and that has been encroached by the private respondent number 7. And since then, they are living there. They are constructing.
Respondent number 7 is the BLLRO.
Sorry, lordship, I'm extremely sorry. The lordship, respondent number 15 and 16.
All right.
So we have lost the complaint before the concerned all authorities.
Page,
lordship, that it will be from page 27. It's to the IC and then lordship, district magistrate. Now that after the
where is the representation to the PWD?
Page 17, lordship. 27, sorry, lordship, 27.
27 is to the IC,
Yes,
to the
Lordship.
PW.
Then subsequently it is Lordship to the district magistrate at page 30. And Lordship to the page 33 to the SDO. And after the receiving this complaint, Lordship, and to the assistant engineer PWD at page 35, Lordship. The same complaint lost to the all concerned authorities. Page 35. That may be the relevant complaint, Lordship. Page 35. Lordship, may kindly consider the page 37. That is, after receiving my complaint, PWD have initiated a proceeding. And
yes, thereafter what
page
happened?
37, Lordship, kindly sees that two.
What happened thereafter?
They have not proceeded further. But
Please
Lordship, may I submit one thing? And after filing this writ petition, they have further initiated the proceeding and they called all the concerned parties for hearing and they heard the matter. And also, Lordship, they found that the land has been illegally occupied by the private respondents. But after that, again, they kept silent, or that
10-2 proceeding has been concluded or not?
No, Lordship. Proceeding has been, hearing has been concluded, but
Final
no demolition or nothing, that sort of.
Final order has not been passed.
That is the final order I have not known.
Where are those documents? You have to file it by way of a supplementary affidavit. Otherwise, how will the court look into all these things? Please come. The petitioner alleges illegal encroachment of government property. Stop. It has been submitted that after the representation was filed before the authority, certain steps have been taken. Stop. Leave is granted to the advocate of the petitioner to file supplementary affidavit annexing documents which arose subsequent to the filing of the writ petition by 11th July. Release the matter on 22nd July 2025. Stop. Let the supplementary affidavit and a notice be served upon the respondents. Affidavit of service filed in court is taken on record.
Grateful.
দেখতে হবে, মনে হয় আছে।
That if the 2024 read, and this for the first time the matter has been heard by your Lordship, Lordship may give some preference to the matter, maybe keep in the because
22nd it will appear in the list.
So I'm grateful.
29 same order as 27.
Grateful.
I'm for the state, Lordship.
Very well. Please give your appearance. Dismiss or default. Great.
Did I appear for the petition?
Yes. Who is the commission?
I am appealing for the commission.
It could be in a time maybe. That before your Lordship goes to the impugned order passed by the commission, may I only place 2-3 pages. The petition filed by the private respondent is at page 27. That if your Lordship takes up page 27 once, with this attachment, at page 28, the incident happened in 2022. My lord, got it? Page 28.
Yes.
Now, the complaint has been registered in 2024 May. The patient was treated in 2022 and the complaint was registered in 2024 May, 2.5 years
later.
Yes. Then, in the complaint, if your Lordship takes up page 28, your Lordship will find that after the treatment, third paragraph, তথাপি শরীর দিনের পর দিন অবনতি হয়ে যাওয়ায় আমি আমার জেলায় ও কলকাতায় অবস্থিত ডায়াগনস্টিক সেন্টারে পরীক্ষা নিরীক্ষা করার পর জানতে পারলাম আমার পেটের ভেতর কিছু একটা আছে এবং শঙ্কিত হওয়ার পর
আত্মীয় স্বজনদের কথা মতো চেন্নাই অ্যাপোলো হসপিটালে দেখাই ও দীর্ঘ পরীক্ষা নিরীক্ষার পরে জানতে পারলাম আমার অপারেশন করার পর গজ বাহির করা হয় নাই, যার ফলস্বরূপ আমি মৃত্যুমুখে চলে যাচ্ছিলাম দিনকে দিন। দেন ফার্স্ট চেন্নাই অ্যাপোলো, দেন কিছুদিন পর আমার আত্মীয় স্বজন আমাকে অপারেশন করে গজ বাহির করার জন্য এআইজি হসপিটাল হায়দ্রাবাদ তেলেঙ্গানাতে যোগাযোগ করেন এবং সেখানকার ডাক্তারবাবুর পরামর্শ মতো অ্যাডমিশন হয়ে অপারেশন করে গজ বাহির করিয়াছেন। এখন আমি সম্পূর্ণ সুস্থ এবং চাষি হিসাবে হালকা কাজ করতে পারছি। So but he approached two hospitals. Then your lordship is reply to this allegation by the petitioner's doctor, page 34.
Page 34.
Yes. The doctor who operated the petitioner,
yes,
he was present. The entire proceeding was done online.
Online?
Yes.
Proceeding, which proceeding?
The hearing.
Oh, hearing proceeding.
It was done online.
Hmm.
Now the doctor kindly sees page 34 once.
Hmm.
He wrote a letter to the secretary of the West Bengal Clinical Establishment.
Hmm.
It said that I am the concerned doctor so-and-so. The said operation was done successfully. Thereafter, the checkup was done on 6th of July 2022, 30th of October 22, 4th of November 22. During this period, no complaint of the patient regarding any abnormality was made by him to me. Then, but it is astonishing.
What is the order of the commission?
The commission has directed me to pay 5 lakhs.
All right.
Starting for, yes. But the order starts from page 42.
Hmm.
My lord will find page 43. We have considered the issue once the foreign body was directed in the USG report done by the done at Kolkata. The patient could have approached any appropriate setup within the state and could give him substantial reduction in the cost of the treatment. It is unfortunate he had to spend a lot of money outside the state. However, that cannot be the guiding factor in deciding the amount of compensation. We feel interest of justice will be subserved if we direct payment of 5 lakhs as lump sum. 40,000.
Where is the error? Where is the error?
But the error is, first of all, the complaint was not considered. Kindly see the complaint once, page 28.
Yes.
The complaint said that the operation was done in 2022. The complainant has approached the commission in 2024, 2.5 years after. Then, the report of the hospitals, 2 hospitals he has mentioned. First is Chennai Apollo, second is AIG Hyderabad. No copy was ever given to us. We could not able to justify our conduct. Third, kindly turns to page 34 once. Was the doctor said? The doctor said that the patient, page 34.
Hmm.
The treating doctor said that the patient came for checkup on 6th of July, 30th of October, 4th of November. No complaint was ever registered before the doctor. Then, it is astonishing story is made by the private respondent before your organization on 5th of May, 3rd of May 2024 after expiry of 2 years. This complaint is a brainchild of the petitioner and after 2 years is a wrongful gain. The story is a cock and bull story. The complaint made out of a untrue story to harass the doctor.
What will the complainant gain by harassing the doctor who treated him?
Kindly sees what is the claim. The claim is that a foreign body was there inside his stomach, which could not be taken out during the time of operation. But had he ever registered any complaint? No. But thrice he was treated by the concerned doctor. Not a single complaint was registered.
At that point of time, he may not have felt the discomfort, pain, or uneasiness thereafter.
No. Kindly see the timing. It's very important. Kindly turn to page 34 once. First is July, then October, then November. 4 months he was constantly treated. Now he's
not treated. He says checkup.
Checkup means it is one kind of treatment. After the operation, we give him the fullest of treatment if there is any abnormality. This is number one. Number two, kindly my lord, have a look to page 28 once. Kindly have a look. I request you. Lordship.
1 minute. Prior to that, private respondent, are you there? Where did you get yourself treated after the operation done by the petitioner?
I went to the my lord Chennai, so and so, my lord, several.
Where are those reports and records?
Nothing was given to us.
1 minute.
My lord, I have within 3 days, my lord, I have my lord supplementary affidavit and file, my lord, before your lordship.
Supplementary affidavit,
No,
did
my
you?
lord, affidavits, my lord, affidavits, my lord, before your lordship, my lord, within 3 days, my lord. All documents, my lord.
You do not have it with you? The story that you have made up is that a foreign body, a gauge was there inside.
My lord, everything with me, my lord. Kindly, my lord, 3 days time, my lord. So we will, my lord, produce before your lordships with affidavits, my lord.
Please come. The petitioner is aggrieved by the
And he got the
order
benefit
passed
of
by
Shastra
the commission. He got?
the benefit of Shastra Shati.
So what? If
No,
he
no.
is entitled to, he will get it.
My lord, he got the benefit.
So what? Why is it so pertinent to mention that he got the benefit? If law permits him, he will get it.
Absolutely.
Then,
Absolutely.
then what is the use of mentioning that he got the benefit? Aggrieved by the order passed by the West Bengal Clinical Establishment Regulatory Commission on 24th May 2024, directing the petitioner nursing home to pay a sum of rupees 5 lakh by monthly installment of rupees 40,000. Next, the petitioner submits that the complaint lodged by the petitioner was after
Private respondent.
more than a complaint lodged by the private respondent. Petitioner and a private respondent was more than 2.5 years after the surgery was conducted by the petitioner. Stop. No complaint was ever lodged before the petitioner.
As it was not within his knowledge.
Stop. According to the doctor who performed the surgery, the story made out by the petitioner is false and frivolous. Stop. Paragraph. Did you pay any installment?
Nothing.
Not.
My lord, not a single document has been given to us.
Very well.
Which has been produced before the
The
commission.
private respondent is directed to file an affidavit disclosing all documents in support of his claim by way of an affidavit by 15th July. Release the matter on 28th of July.
May I reply to this?
Yes. It will be open for the petitioner to file an exception to the affidavit filed by the private respondent.
Great. 28th of July. Very good.
I beg to appear for the private respondent number 5 and 6. Lord, I have a preliminary objection, Lord, whether this writ petition is maintainable in the present form. Lord, kindly have a look at the persons who have been arrayed as respondents. Respondent number 3 and 4. Whether that's permissible in law or not.
Who is the petitioner?
I am the petitioner.
All right.
Mr. Gopal Chandramono, led by due to illness not come, Milord, I am appearing.
All right.
It is a challenging the order passed by Milord the
Kindly have a look at the array of respondents, my lord. There is a specific bar under the Consumer Protection Act. In any event, my lord, a court of law.
Wait, 1 minute. Let me see.
3 and 4.
Four is the National Consumer Commission.
They have been arrayed as respondents.
Who is Shudipto?
Well, I am Shudipto. and Torun Kumar Rai Chaudhuri.
You are the private respondent.
Yes.
Yes. So where is the
raising
difficulty?
the issue, my lord, whether this can be done or not.
Private respondent, if is to be impleted, then how will they be impleted?
Respondent number 3 and 4, my lord,
3 and 4.
Kindly have a look, my lord. State Consumer Redressal Commission and National Commission, how can they be made parties, my lord?
Anyway, it doesn't matter. He is aggrieved by the order of whom?
Aggrieved by the order of the National Commission.
National Commission. Yes, what is the dispute? What is the order of the commission?
Order of the commission, my lord, this is a matter, the order, commission affirmed the order passed by the, my lord, the state commission.
All right.
So what is the matter, my lord? The petitioner is the landowner. My lord, he entered into the development agreement with the my lord, private respondent number 7. Only, my lord, development agreement, unregistered only allocated, my lord, reflected there only. There's no power of attorney, nothing, no given any, my lord, document executed to give a sell the property. My lord, all on a sudden, my lord, petitioner number 1 and 2, my lord, is a jointly, my lord, file a application before the state commission. My lord.
Petitioner number 1 and 2.
Petitioner number, no, Torun, petition
My
number.
lord, I am the complainant. I had filed the application before the
Complainant
State
filed
Commission.
an application.
State Commission passed an order in my favor, affirmed by the National Commission.
5 and
It's an
6.
appealable order. My
Five
lord,
and
I shall address.
My lord, the first of all, the valuation of the property, my lord, flat below 10 lakhs, my lord. Thereafter, my lord, jointly, my lord, file a case for make out a jurisdiction before the state commission. Secondly, my lord, there is no authority given by the landlord to the, my lord, developer to sell out the property. The agreement.
Why will the writ court go into all these things?
Writ court, my lord, there is a, my lord, Supreme Court order, my lord, against the
Yes.
my lord, order passed by the National Commission. The writ court is the jurisdiction.
No. Writ court has certainly the jurisdiction, but the disputed questions of fact, the writ court cannot entertain.
No, disputed fact, my lord, I am challenging, my lord. There is no, my lord, authority by the developer to, my lord, sell out the property. But the
Go to the civil court and get things done. If the writ court will do.
Court, my lord, challenging the order passed by the National Commission, my lord, writ court has a jurisdiction, my lord.
Lord, may I only make
My lord,
one
kindly see the
submission?
judgment, my lord,
Yes, my
Supreme
lord.
Court
I
passed
know what
an order.
The
judgment my learned
judgment
friend
is
would refer.
there. The writ court certainly has a jurisdiction. But difficulty is because of disputed facts, the writ court will not
one thing, my lord,
entertain.
transparent way, my lord, if there is any power of attorney, my lord, shows by the private respondent that he purchased the property knowing fully well that the developer has enough capacity to, my lord, transfer. Without, my lord, knowing fully well that the developer has power or not, my lord, you enter into this
These
agreement.
were all considered
An
merits.
agreement, my lord, kindly see, some person enter into the agreement, thereafter, my lord, pen through and another person name also inserted. That is also, my lord, allowed by the consumer firm. My lord, kindly see the, my lord, agreement for a moment, my lord.
Please come. The
Page number
petitioner
40.
challenges the order passed by the
Lord, may I only make one submission on law?
National Consumer Disputes Redressal Forum. Stop. The dispute revolves around a power of attorney and an agreement of development entered into by and between the parties. Stop.
Not enter, my lord, dispute of matter.
আচ্ছা শুনুন কি বললাম ওটা পাওয়ার অফ অ্যাটর্নি অ্যান্ড এ ডেভেলপমেন্ট এগ্রিমেন্ট না এগ্রিমেন্ট অফ ডেভেলপমেন্ট কিছু একটা বললাম তো ওখানে শেষ করে দিন দরকার নেই learned advocate for the petitioner submits that that the parties did not enter into the development agreement. Stop. The power of attorney is also not signed.
Developer agreement, my lord, landlord and developer, my lord, enter unregistered agreement.
Then,
but the landowner, my lord, not given any power to the developer to enter into the agreement with the third party for selling out the flat.
আচ্ছা কি বললাম power of attorney is
not given.
The power of attorney has not been given by the landowner to the developer. For sale of property to third parties. Stop. Neither did the owner enter into any development agreement with the developer.
Owner, my lord, enter into the development agreement with the developer. Or Lord allocation, Lord reflected in the development agreement.
Right.
But the developer not given any power to, owner not given any power to the developer to enter into the agreement for selling of the any
Yes.
part and portion of the premises.
ঠিক আছে।
And then, there is no
With the
agreement between
developer,
the
with the
owner and
developer for sale of the any portion of the
concerned premises.
Structure to be constructed. Stop. The aforesaid contention is disputed by the learned advocate representing the private respondents. Stop. It has been submitted that there are documents in support of
There's
the
a tripartite agreement which he has signed.
No.
আচ্ছা কি বললাম it has been submitted that there is already an agreement which has been signed by the owner.
That's a tripartite agreement.
Agreement with the developer and owner.
Owner, the developer, and the intending purchaser. Stop paragraph. Upon hearing the parties, it appears that there are several disputed questions of facts which cannot be resolved by way of a writ petition. Stop. Next, in view of the above, the court is not inclined to exercise jurisdiction in the matter. The writ petition fails and is hereby dismissed. Stop. Dismissal of the writ petition will, however, not stand in the way of the petitioner to approach the competent forum for remedy in accordance with law if so advised. It a petitioner.
Competent civil court mention forum also dissolve this matter.
Next.
I am for state mother.
My lord, I am for the petitioner.
Yes.
My lord, petitioner name sudden.
State Election Commission.
Yes, my lord, I am appearing, my lord, my lord. I may require 1 week time for filing my report, my lord, because there is I require to file a report in this matter.
Last occasion, direction
Yes.
was given by this court, my lord, to submit.
Where is your instruction?
Yes, my lord, that is why I require the 1 week.
Where is your instruction? Report
not-
comes.
It has not yet come, my lord. That is why I am praying for 1 week more time, my lord.
Why will instruction not come?
My lord, I have missed the last order, my lord. This is only on the fault on my part. My lord.
You've missed the last order.
My lord, I didn't.
Nobody
appear.
was present
Yes,
in
my
the
lord,
last
that is why
occasion.
yes. No, one junior appeared. Yes.
Learned advocate.
Yes, he has indicated junior that appeared, my lord. He has indicated.
What is the grievance?
My lord, grievances, my lord, my name is was in the voter list. Suddenly, name has been struck off. Thereafter, I made an application, but application. Then they kindly come page 24.
Yes.
The concerned department intimated that one Bimal Sardar, Pita Sukhdev Sardarer এর ভিত্তিতে আমি এটাকে ক্যান্সেল করেছি বাংলায় চিঠি নেক্সট মাই লর্ড দি টার্ন ওভার দি নেক্সট বেঞ্চ হু ইজ বিমল সর্দার বিমল ইজ দ্য সর্দার ইজ দি প্রধান হি ইজ দি প্রধান হি ইস্যুড সার্টিফিকেট মাই
Where
নেম
is your objection before the authority?
ইয়েস মাই দাঁড়ান
Where is your objection before the authority?
There is no objection, my lord. Only the application was made, my lord. That application got.
You are not ready with the report, not the instruction. Let the petitioner make his submission.
মাই লর্ড কাইন্ডলি পেজ 24
Yes.
তথ্য জানার অধিকার আইনে 205 মোতাবেক
No,
তথ্য
that
প্রদান।
is under the Right to Information Act. Where is your objection with regard to the act that has been committed?
My lord,
Nothing.
the representation, my lord, this is the last order, page 39. I made an application for correction on the record.
Yes. Last order. there is
My name has come, but in place of instead of my father name, my wife name has come. I
Yes,
made an
come.
application for correction.
The
And by
petitioner,
the correction, the application was rejected.
the
Application was rejected.
Only one thing, my lord, in this matter, my lord, the petitioner describe himself as Son of Bhattacharya. My lord, I didn't, my lord, the Pradhan. My lord, what happened, my lord, under the name of Sanod Ghorambi, the same person, my lord, the collecting the as my lord, the job card and collecting the money.
very good.
No, my
You
lord,
also,
absolutely
the
false.
petitioner, alleges that his name has been wrongly inserted in the his name and description
Name is
has
correct, but
আচ্ছা
my-
name ঠিক হয়ে গেছে
in place of
that
my
his
father's
that
name,
his
his wife's name.
father's name has been wrongly inserted in the voters list. Stop. According to the petitioner, instead of his father's name, his wife's name has been inserted. Stop. From the documents annexed to the writ petition, it does not appear that the petitioner brought the alleged error to
38
the
is-
notice of the
38 is my
authority.
Page 38 my online, this is a system, my online application. 38 is my application for correction of the records.
38, nothing is legible. Nothing is legible from 38.
This is the application for correction. And
Where is the application?
39 is the order. 39 is the order.
38 is the form 8.
Form rejected. Correction form is rejected.
Rejected for changing the name of your wife?
Yes.
Your wife's name has not been taken away and your father's name has not been inserted?
Inserted, my
Has not been done?
not been done.
It has been rejected?
Yes, my
আচ্ছা কি বললাম তার আগেরটা বলুন instead of his father's name his wife's name has been incorporated বললাম stop. It has been submitted that the application made for correction has been rejected. Stop paragraph. The court is not aware as to why the application made by the petitioner seeking correction of his father's name has been rejected by the authority. Stuff next. In view of the above, leave is granted to the petitioner to make a formal application.
Respondent 3, my lord.
Before the subdivisional officer Baruipur, highlighting all the discrepancies in his description. Stuff. On receipt of the application from the petitioner, the subdivisional officer Baruipur shall deal with the same in accordance with law at the earliest. Stuff. If the grievance of the petitioner appears to be proper, the necessary remedial steps shall be taken. Stop paragraph. It will be open for the subdivisional officer to conduct necessary inquiry to ascertain proper facts prior to making any changes in the voters list. Writ petition disposed.
I mean,
Yeah.
director to produce the document, that document is there.
The SDO will conduct inquiry. Next.
This relates to fair price of my grievance is, my lord, the private respondent who has got the grant, my lord.
But then why will fair price shop be taken up by this bench and not by group 8 bench?
Actually, my grievance is, my lord, regarding tender, regarding
Tender.
selection.
All right.
It's not any selection of the private respondent has been selected. My
Uh.
grievance is, my lord, two criteria has not been fulfilled. It is page 17. Clause
Selection of ration dealer.
Selection of ration dealer. He says the tender process.
Selection of by way of tender process.
Ration dealer যেটা হয়
Tender for what?
Tender for selection of
License to a fair price
Yes.
shop is different.
license of fair price shop.
Then it will go before the group 8 bench.
Lordship should be 8.
Yes. The matter relates to issuance of license in respect of a fair price shop. Stop. This bench does not have the determination to decide the issue. Stop. Let the same be released from the list of this bench and be placed before the bench taking up group 8 matters. Essential commodities. Yes, next.
35.
Yes. What is the matter?
Petitioner is a proprietor, petitioner is a proprietor of chartered accountant firm. In the district of Uttar Dinajpur, society, the district magistrate and the CMOH was the president and secretary of the society, and later the CMOH made a complaint about the defalcation of amount, and Raiganj police station. In the Raiganj police station, 4th of August 2001, one case was registered against this matter. And in this FIR, the petitioner was not named. Later on, in the charge sheet, petitioner name was entitled in the charge sheet. But petitioner made the audit. Petitioner made this.
What is your prayer? Please say.
Petitioner the seeking is the compensation.
Compensation for what?
Compensation for his. Kindly come to the page 30.
30?
Yes.
Yes. There are so many cases pending against persons before the competent court. And if everybody prays for compensation, now you'll pray compensation because this writ petition was filed a year back and the court is unable to dispose it of. How much compensation?
Petitioner seeking compensation for his faulty engaged in this case. Petitioner was not engaged in the defalcation of amount or any kind of forgery.
Please come. The instant writ petition has been filed by the petitioner seeking compensation for the delay in disposal of a criminal case which was pending since
the matter has been disposed of in
pending from when?
Pending from 2001 to 2000.
Pending from 2001 till 2020. Stop paragraph. The court is of the opinion that writ court will not be the competent forum to adjudicate the dispute. Stop. In view of the above, the instant writ petition stands dismissed. Stop.
Kindly direct the
Dismissal of the writ petition will, however, not stand in the way of the petitioner to approach the competent forum for relief in accordance with law if so advised. Service taken on record.
The respondent to consider the representation.
No, sorry, sir. Eight and in.
My lord, in 36, I am for the caveator, complainant. My submission.
36 and 40 may be taken up together, arising out of the same order passed by the commission.
Yes. 40 number file deben. Yes, please.
No, my lord, what I was essentially questioning is the decision-making process of the regulatory commission. No, my lord, why I say this? My lord, the facts are, my lord, the private respondent number 4, my lord, he lodges a complaint before the commission. In his complaint, his case is that his wife, my lord, was on the way of achieving motherhood. My lord, she was admittedly having a premature delivery. Now, my lord, she was initially, my lord, taken to Mission Hospital, Durgapur. My lord, Mission Hospital, Durgapur, at the time of admission said that they do not have NICU facilities. So, my lord, they left the patient. Now, my lord, the patient thereafter went to Health World Hospital, the petitioner in item number 40. Health World, my lord, admitted the patient. My lord, the patient was operated. My lord, a child was born, but the mother did not survive. My lord, thereafter, my lord, before the commission, a complaint is lodged. If your lordship sees the complaint, the primary allegation in the complaint is negligence as against the doctor. Now, my lord, lordship knows, my lord, as per the Act of 2017, my lord, section 38, the commission cannot adjudicate medical negligence because my lord, medical negligence has to be adjudicated by the concerned state medical council. Now, my lord, if your lordship, my lord, kindly comes to the order. Now, my lord, in the order, if your lordship sees, my lord, page 64 of the order. My lord, first is, my lord, all the submissions of all the parties are recorded. And now, my lord, page 64, the commission, my lord, comes to its findings. My lordship is getting our view. Now, my lord, the commission, without ascertaining anything, my lord, imposes 10 lakhs upon mission and 5 lakhs upon Health World. Now, my lord, there is no finding by the commission as to how it has arrived at the figure. Now, my lord, this issue, my lord, with regard to the procedure in which the commission is functioning had come up for consideration before this honorable court. Now, my lord, kindly has a look at this judgment. But kindly has a look at the order passed by the commission. No finding as to how it has quantified 10 lakhs in respect of mission. My lord, the patient came to mission. Mission, my lord, broadly said, we do not have NICU facilities. Please shift the patient elsewhere. The patient thereafter went to Health World. In Health World, the patient was immediately taken at the emergency, taken to the ward. My lord, the child, my lord, taken to the operation theatre. Child was born, and thereafter, my lord, kindly comes to the findings. There is, my lord, how did it quantify 10 lakhs and how did it quantify 5 lakhs? My lord, there is no elaboration on this. And my lord, the honorable division bench of this honorable court, my lord, in a judgment of my lord, BM Birla Heart Research Center has categorically dealt with this issue, that the negligence of a doctor and the negligence of an establishment are intermingled. So the commission, as soon as it finds a complaint of negligence, it cannot adjudicate.
Page 65, the commission opines that the establishment is liable for hospital negligence, not medical negligence.
But the complaint initially was medical negligence. Kindly comes to the complaint.
Very well. Assuming it is for medical negligence, but no decision has been taken on that. The commission was of the opinion that the patient ought to have been treated in such and such manner. As a hospital, it was your responsibility. That is the reason hospital negligence is there.
Now, my lord, what the commission does is, my lord, the patient did not die in mission. Patient died in, my lord, Health World. Now, if your lordship...
No, it's not the death. The factors which led to the death.
Now, my lord, section 33 of the Act, lordship kindly sees. My lord, section 33 lays down, my lord, the mode in which the commission has the power to grant compensation. Now, my lord, section 33 kindly sees, just a second. If it is death, then only, my lord, 10 lakhs can be awarded. Now, my lord, this is where, my lord, I am challenging the decision-making process. My lord, A is which may extend to 3 lakhs in case of simple injury. B is which may extend to 5 lakhs in case of grievous injury. And C is which shall not be less than 10 lakhs in case of death. My lord, the patient did not die, my lord, in mission. That is an admitted state of affairs. Mission has been awarded 10 lakhs. For what? My lord, the commission did not quantify as to how it has arrived at this compensation amount. And my lord, this same issue, my lord, came up for consideration before this honorable court in a judgment. Now, my lord, here, this honorable court, my lord, has absolutely, my lord, deprecated, my lord, my lord, decision-making process of this commission. But I shall, but kindly comes to internal page of 2 of this, my lord, order. And my lord, this order has not been challenged till date by the commission. The issue in the present petition is whether the impugned order complied with the relevant provisions of the Act of 2017. The Commission has been given wide powers under the said Act to regulate its own procedure and not be bound by the procedure laid down in the Code of Civil Procedure. Section 44 subsection 2 gives the Commission the same powers as that of a civil code. The documents annexed to the present writ petition start with the complaint filed on 8th October 2020, followed by the reply of the petitioner on 24th November 2020. The only other document is the impugned order. Well, that's same thing here. The impugned order passed by the Commission indicates that the chairperson and 4 other expert doctors merely narrated the facts leading to the unfortunate death of the daughter of the petitioner. The narration concludes with the opinion of the experts to the effect that had the complication been detected on time, the life of the patient could have been saved by appropriate measures. The imposition of penalty follows immediately thereafter. As in all adjudication which culminates in an order, there must be a bridge between the facts and the conclusion. The bridge in essence is the body of the reason which leads to the conclusion. This court has been unable to find any bridge or link between the facts and the penalty. Giving reasons is the essential in all matters, but it is non-negotiable whether the result is punitive against a particular person or entity. The person who is at the receiving end of the direction of the order must know the reasons for which the penalty has been imposed. Section 44 subsection 1 of the Act mandates that the Commission shall be guided by the principles of natural justice and discharge its functions under the enabling powers vested in a civil court. 44 to read together, the legislative intent mandates that the Commission upholds the parties' right to a fair hearing before taking a decision. Section 32 contains...
In this case, was a hearing given?
But hearing was given.
There was...
But hearing was given. My lord, I was not even allowed to, my lord, cross-examine because, my lord, it's a fact-finding, my lord, authority, the Commission. A complaint is lodged, a reply is filed, and then the Commission starts adjudicating.
Then you were heard in the process.
My lord, heard, my lord, kindly see section 44 subsection 2 once.
I'll come to the section, but then you were heard.
I was heard.
Some type of hearing.
I was heard, but my lord, imposing that amount of penalty on me.
Quantification.
No reasons.
The
Quantification as to how the Commission reached at 10 lakhs.
All right.
My lordship has seen, my lord, section 33, in case of death, it is 10 lakhs. Mission, admittedly, the patient did not die there. Mission referred it to Health World. Health World, the child was saved. Mother, my lord, we tried our utmost efforts. We could not save the mother. Health World has been granted 5 lakhs. And if your lordship, my lord, sees the opinion of the experts as laid down in the body of the order, my lord, the experts said that, yes, there was a delay. The patient, my lord, she developed a critical condition in the morning. My lord, after 2 hours thereafter, my lord, she is taken there. From there, she is taken to Health World. Health World immediately takes her to the emergency. But a patient who is not our patient, if he is brought to the hospital, he has to be taken to the emergency first. We immediately took her to the OT. We saved the child, but the mother, my lord, suffered. And kindly sees the reasoning process of the Commission. My lord, no reasons as to why I am imposing 10 lakhs on you. No reasons as to why I am imposing 5 lakhs on you. Well, no opportunity to, my lord, granted to me, my lord, to file an affidavit. No opportunity, my lord, granted to me, my lord, to cross-examine, nothing. Straightforward and order is passed.
See, page 64 you placed.
Lordship.
Our view. The first sentence is, we heard the parties at length.
Heard. But I do not deny that. The Commission hears us.
What is your submission?
My lord, my first submission is, my lord, how this writ petition is maintainable, because, my lord, on one hand, they are saying that there are certain procedural defects. If that be so, they should have preferred a civil revision and application instead of a writ petition, because I am unable to understand, your lordship, where their natural justice, how they are prejudiced. Secondly, my lord, my learned senior friend has submitted that the patient did not die at their hospital. Yes, but there, my lord, is a 23-page judgment where everything in details have been explained and corroborated through all the expert opinions of all the doctors as well as the hospital as well as clinical establishments, wherein it has been stated that, my lord, the patient died because of lacuna on the part of the initial hospital who refused to give treatment, did not admit the patient at the very behest when the patient was brought. Prior to bringing the patient, my lord, the patient called the hospital. But even then, if the patient was given an assurance, their USG was done in the mission hospital, wherein in the USG, it is reflected, my lord, there is a ruptured uterus, which is of grave emergency, which has to be addressed immediately. But despite that, when USG was done, when they found out that there is a complication, immediately, just to show off their responsibility, they told that we cannot admit, and they have sent the patient to a different hospital. Now, my lord, regarding what my brother has said, my lord, section 21, may I, my lord, once again come to the act itself, my lord. And another thing, he has stated that yes, it's the differentiate between medical negligence and whether there is a negligence on the part of the hospital. My lord, one thing I will candidly and respectfully submit before your lordship, my lord. In 2025, there is WHO protocols, there are protocols of NABH, national, there is protocols of N number of regulatory bodies, QCI. Why these protocols are being made before the hospitals? Because, my lord, standard is of primordial importance. It's not that a negligence committed by doctor. Yes, a patient may die, may suffer due to negligence on the part of the doctor. But, my lord, when the negligence is on the part of the hospital, who will adjudicate that? I am asking before.
You file your affidavit.
But I was praying for a stay of operation of
My
this
lord,
order because, my lord, the commission in such as per section
my lord, one
20
final
45, my lord.
Judgment dated 30th
My lord, may I?
2024,
My lord, one-
passed by the West Bengal Clinical Establishment Regulatory Commission, is impugned in the instant writ petition. Stop. According to the petitioner, there are procedural defects in the entire proceeding. Stop. Proper opportunity to defend was not given to the petitioner. Stop. The basis of quantification of the compensation amount is not reflected in the impugned order. Stop. Learned advocate representing the private respondent supports the order of the commission. Stop. Let a report by way of affidavit be prepared and circulated by 15th July, released on 28th. Exception to the report may be filed prior to the adjourned date.
Report will be filed by the
Private respondent.
My lord, one more sub.
Have much say in the matter.
My lord,
Kindly
my lord,
grant
one
me,
more
my lord,
submission. My lord, kindly cease, my lord. I have an order in my favor, but they have not paid. They have, on the contrary, they have preferred a writ petition, and they are saying that case is pending, so nothing will happen.
But this is exactly why, my lord, I would be praying for a stay. Kindly see section 20 and 45.
It is pending for quite some time. It is
But
been
we have
directed
filed
to
it
appear.
We have filed it.
This proves their demeanor.
No,
my
no, it's all right. But
Could
then
have
the
paid and
matter
come.
is due to appear on 28th. Please wait. Affidavit of service filed in court is taken on record. দুটোকে with করে দেবেন।
But I have a very tough opponent to defend, my lord. My learned friend is an MBBS MD.
So what?
No, that will not prejudice the case, my lord.
8th of July, this month.
Yes, this month.
I am grateful, my lord.
40 also, my lord, I think. 40 is.
Yes, two matters.
Both the
36 and 40. 37.
For the petitioner, my lord. The affidavit of service, my lord.
Yes.
My lord, the petitioner made several RTI. My lord, the petitioner made several RTI applications, my lord. Lastly, petitioner made an RTI application seeking his Weimar sheet in a selection process of 2017, my lord. The petitioner participated in Gram Panchayat secretary recruitment process 2017. My lord, the petitioner initially asked for
Who
his
conducted the examination?
My lord, the Panchayat authorities, my lord. Well, I have made parties, my lord. The two, my lord. Respondent number 2. The member
Who
secretary.
is for the
district-
state? Nobody is there. Yes.
My lord, the petitioner initially made RTI application to know his marks, my lord. That was replied. But thereafter, when the petitioner asked for his Weimar sheet and the last selected candidate Weimar sheet, my lord, they have given reply that the Weimar sheet is not traced out. My lord, kindly come to page number 62, my lord. This is
Yes.
reply from the first appellate authority, my lord.
Yes, this is to inform you that you received your reply. Then
Page
what
70,
happened?
kindly see, page 70 is the reply from the SP.
51, my lord. Page 51. This is, my lord,
24th of November 23.
এই একই 51 না 17 দুবার লাগিয়েছে
ওই সব দুবার করে আনে
24 নভেম্বর
62 70. Yes. Name of the candidate joined. What you are Sundipon TRE. Copy of the OMA sheet has not been traced. 102 candidates were recommended and got appointment.
Thereafter, my lord, petitioner made, my lord, application before the second appellate authority, my lord. It is not replied with.
It is not traced, it is not traced. What extra reply will they give? Anyway, what is to be done? Yes, state respondents, OMR sheet not traced out.
Well,
What
kindly
will be
see
your
the
reply?
panel. No marks is given.
is the
Marks has also not been disclosed.
No marks is
it was actually I don't have the report today, but let me take a specific instruction on this because so far I have been told that this is not available. That's why this has been pointed out at that point of time. Subsequently, let me take out a report with whatever it is the situation.
I
But
don't think there will
perhaps,
be any
yes,
subsequent report.
yes,
There
yes.
cannot be.
There cannot be.
How many vacant posts were there? 102 candidates were recommended.
Yes.
How many posts were there? Where is the advertisement?
My lord, advertisement is not annexed, my lord.
Not annexed.
No, my lord.
You want to know your marks?
Lord, that is given.
Your marks
that,
is
my
given.
lord, my marks is given.
Where is it?
My lord, kindly came to, my lord, page number 20. Page number, reply is 19. Got them.
22, it has been intimated that you are not selected for the post of Gram Panchayat. Your name is not included in the panel. A photocopy of the panel is there. But are the marks
Thereafter, my lord,
disclosed?
24.
24.
Detail category wise, my lord, they have given the
Approximate number of vacancies is 76. You are for Gram Panchayat secretary or what? Post?
my lord, Gram Panchayat secretary.
Secretary. 76. Category wise provisional selection for the post of Gram Panchayat secretary is there. Category wise provisional. Is the marks disclosed? Your panel marks is, where is your
31.
name? Where is your name in the panel?
My lord, my name is not in the panel.
Because you were not selected at all.
My lord.
Where is the error?
My lord, I got the, my lord, information. They have provided my marks. My lord, I have doubted, my lord, that I would get the more marks. And that is why I asked for the Weimar sheet, my lord. My marks is given in page number 31.
Your marks is also there. Yes, OMR. If it is not there, another SSC matter will come up.
Let me come up, let me just indicate whatever is passing through your lordship's mind. Let me just come back with whatever is available, my lord. I'll place before your lordship.
Please
Yeah, we
come.
cannot.
The petitioner participated in a recruitment examination for appointment as Gram Panchayat Secretary, held in the year 2017. Stop paragraph. The petitioner has been provided the panel of selected candidates and also the marks given to each of them. Stop. The marks obtained by the petitioner in the examination is also disclosed under the Right to Information Act. Stop. The petitioner intends to obtain a photocopy of the OMR sheet. Stop. The same could not be provided to the petitioner with the observation that the OMR sheet has not been traced. Stuff next. The petitioner apprehends that the marks allotted to him are not correct and seeks a photocopy of the OMR sheet. Learned advocate representing the state respondents is directed to produce a copy of the OMR sheet of the petitioner. Stuff released on 22nd of July. Service is taken on record.
I'm for the petitioner. Matter relates to registration of forged deeds. Originally, Billopato Pal was the owner. Page 10. I have annexed the record of rights.
Yes.
And page 11, the yardship certificate issued by the municipality, 11 legal yards are there.
Yes.
Page 11. But the seller is Sumon Pal, page 15.
Page?
Page 15.
Yes.
Deed, seller Sumon Kumar Pal. And page 17, and the deed. May I read? Jela Uttar Chobbish Pargona Thana Noihati, ADSR office Noihati Elaka, Habili Shohor Pargona Antargata Noihati Puroshabhar Odhীন, Mauja Gorifa, LR 2599 Khotian Bhukto, LR 1294 Dag Bhukto, আত্মশতক জমি যাহা বিল্লপদ পাল মহাশয়ের স্বনামীয় হাল এলার জরিপে রেকর্ডভুক্ত সম্পত্তি হইতেছে, উহাতে তিনি ভোগ দখলে কায়েম থাকা অবস্থায় স্ত্রী বিহনে একমাত্র পুত্রকে তার ওয়ারিশান রাখিয়া গত ইংরেজি 31 তারিখে পরলোকগমন করিলে তার ত্যক্ত সম্পত্তি আমি অত্র দলিলের বিক্রেতা পুত্র বিধায় পিতার ওয়ারিশান সূত্রে প্রাপ্ত হইয়া মালিকানা সরকারে, দিস ইজ দ্য stated in the deed, my lord, and number 1. Thereafter, my lord,
What are you praying?
but for cancellation of the deed.
Why before the writ court and not before the civil forum?
But the provision is there, my lord. Page section 82
What does
of
it
the
say?
Registration Act. Penalty for making false statements, delivering false copies or translations, false personation and abatement.
Right.
My lord,
How is the authority supposed to know that there has been a false declaration? How will the authority know?
my lord, here, my lord, whoever intentionally makes any false statement,
Yes.
whether
You say that this statement is false.
Okay.
The other side will not accept it. There is a regular deed. You approach the civil. What is your submission?
Pursuant to the my lord petitioner's representations, an inquiry
Was conducted.
Yes, my lord.
Then what happened?
But what is the outcome of the inquiry, my lord? I am not told. Because that is 13
October 2023, my lord, the hearing was conducted, my lord.
Then
My lord, the outcome of the hearing I am not aware, my lord. If my lord,
who are you representing?
Appearing for the private.
What is your submission?
My lord, unless there is a declaration by the competent civil court, my lord, the registering authority cannot cancel the deed.
Yes, what is your submission with regard to the 11 legal heirs of the person concerned?
My lord, after the deed was registered, we have purchased by the other co-owners, my lord, by separate registered deed.
No, I didn't follow. Who are you? You are the
One of the-
subsequent purchaser.
Oh, you're the purchaser. Yes, my lord, I'm the subsequent purchaser. I am the respondent number 9, 10, and 11. My lord, after that deed was registered by one of the co-owners, and other co-owners have registered the deed after the register.
Other co-owners have also registered deed.
Also registered.
But he is saying that he is only the legal heirs. But in the
Petitioner is Shamol Kumar Pal.
Kumar Pal.
Right.
And
Olok.
11 legal heirs are there.
Yes, one has come forward and one has sold. So there must be 9 separate.
9.
Right. What about the 9? Are they parties over here?
No, they are not made parties.
Then why, upon your submission, which authority will come?
It appears that the deeds are forged, my lord.
How?
He is
Prima facie.
only legal heirs.
Where from? Relying upon page 11?
Yes.
Who knows whether page 11 is false or not? Who is going to certify page 11 is false or genuine?
Issued by
Nobody knows.
one order, may I hand up, my lord?
No, do not hand up any. The petitioner alleges that the deed which was registered, that the sale deed which was registered for sale of the subject property in favor of the private respondent is false. Stop. An objection was filed before the registering authority and the same is alleged to be kept pending. Learned advocate representing the state respondent submits that an inquiry was conducted by the authority, but the
date of hearing was
outcome of the inquiry is not known. Stop. Learned advocate for the private respondent submits upon instruction that the registering authority does not have the right to cancel the registered deed of sale. Paragraph. The learned advocate representing the state respondents is directed to produce before this court the fate of the inquiry conducted by the authority. Released on 28th of July.
No.
Grateful.
Application was made for the purpose of demarcation under the Bengal Survey Act.
Number 6, 7, 8.
Wakalatnama has been filed? Yes.
The application was made for the district benefit for the purpose of for demarcation in terms of the Bengal Survey Act, because there is the only provision left for the purpose of survey of a private property comes within the purview of Bengal Survey Act, where it is the only person is the district authority is the district magistrate who can effect the survey. Now this came up for consideration before this honorable court also. Pratiprakash Banerjee Sahab's judgment today.
Yes, then what happened?
And yes, this provision is there because it is the year of 1860, but it was continued because by way of adoption, still it is in force. So only the district magistrate has the power to effect survey in a private land if there is dispute here the boundary line. Right. And I have raised the dispute. And
let me see the act once.
Yes, yes.
Survey Act, my lord, if you lordship, my lord, 1875, my lord, between Jamindar and tenure holder.
Grateful to my lord, friend.
State Acquisition Act came. Thereafter Land Reforms Act came.
Oh, yes, yes.
And the State Act.
This is the judgment and this is the statute.
Applicable in this case.
Yes.
That is 1875.
Yes.
Tenure holder and Jamindar.
Definition.
Yes, yes. একটা ছিল সেপার করে দিচ্ছি।
West Bengal, Bihar, Orissa.
Yes.
Will it still be applicable?
Yes, Manakali considers the judgment which I handed over to your lordship, passed by the coordinate bench of this honorable court. এই কপি ছিল আমি ইয়েতে দিয়েছিলাম। আমি দিয়ে দিচ্ছি দাদা, দেখুন না যে ফেলতে কপিটা। Because the government of India act came after that it was adopted. So after adoption, my lord, still
No, it says that it may be possible only when there is sufficient ground of apprehension that there may be breach of peace of the locality for demarcation dispute.
yes, that's I made an application. It is for the authority to decide.
Appears that despite representation made, no such act has been done.
One particular proceedings was is directed. I cannot take that advantage here. I can approach the authority who will consider in the periphery of this act whether I am entitled to get that order or not. If I am entitled to get that order, I can pursue. If I am not, then I have the provision of appeal. The argument which I advanced by my senior friend is that the applicability of this act that was taken care of in the graduate.
What happened to this writ petition? Is it still pending?
No, my lord. After that one, the authority has been taken into consideration for the purpose of this was kept ready for the purpose of report what authority has
Obtaining
done.
the report. Then what happened? A report came.
After that, there's not
Nobody
been
pursued.
Nobody pursued. I cannot be lost in two eyes, my lord. The same argument which my learned friend argued, my lord, that was the precise argument which I have advanced.
Special officer on the army shall submit a report before the school. Never will not take exception.
My learned senior friend wants to consult
Be
with
done under the order of supervision of Mr. Robinson. What is the stand of the state?
No, my lord, kindly have a look this writ petition page number 91. Whether what is the prayer made before your lordships, my lord, before this writ petition, my lord, I don't know, my lord, kindly have a look this page number 91. The matters order, my lord, same person, my lord, file a writ petition before your before the my lord coordinate bench, my lord. And pass this order, my lord, in such circumstances, since the private respondent are not claiming any right on the basis of the document so and so, the private parties are liberty to avail their respective remedies before the appropriate court in accordance with law.
Hmm.
That matters already, my lord, disposed of, my lord, whether there was, what is the prayer and what is the nature of this prayer, my lord, I don't know, my lord. Kindly have a look. This.
Here, the court has given the right to the party to approach the competent forum, right? The petitioner has approached the district magistrate for conducting a survey. What is your stand?
My lord, I shall instruction from this. My
Why
lord.
did you not take instruction whether this law will apply or not, whether you can do it or not?
My lord, kindly, my lord, 2 days time, my lord.
2 days time.
My lord. 2 or 3 days, my lord.
Please come. The petitioner seeks demarcation of certain private properties in terms of the Bengal Service Act, 1875. Stop. An order delivered by a coordinate bench of this court on 16th January 2018 in WP 14465 W of 2017. Lokhikanto Chakraborty and another versus such and such reported in ETA. In support of the submission that the provisions of the Bengal Survey Act can be made applicable in the instant case and government Amin can be engaged for demarcation of private land.
Section 42.
Learned advocate representing the state respondents is directed to obtain necessary instruction released on 22nd of July. Take note of the act and the judgment. This is very important. Whether the government Avins can
power of this, my lord, collectoral and my lord.
Yes.
This has a far-reaching effect. That is why, my lord, I, along with the judgment, I have.
Very well. Affidavit of service is taken on record. Yes, call the next matter.
22nd. 22nd July.
Yes.
Get foot, your lordship.
41. Wait, please, your lordship. Lord, I'm appearing on behalf of the petitioner. But this is challenging, my lord, the petition has been preferred, challenging 2 show cause notices issued by ROC. My lord, where ROC has alleged me.
Registrar of Companies.
I have also, my lord,
Official liquidator.
Respondents are there, my lord, ROC and official liquidator.
Your company has gone in liquidation.
It's admitted it's gone into liquidation, my lord. And I have been referred to as the director, your lordship, where I have specifically stated that I am not the director. So, my lord, this is the, therefore, my lord, to, my lord, withdraw the notice and, my lord, delete my name as the director. My lord, this is why, my lord, liquidation has been preferred. My lord, just indicate, my lord, where the show cause notices are. If your lordship kindly takes page number 10. This is the first notice that was issued by ROC, my lord, MCA. 9th February 2024, my lord, seeking some clarification under section 206 of the Companies Act. Now, my lord, subsequently, your lordship, these were their findings. If my lord kindly turns to page number 12. 15th February 2024, my lord, these were their findings. My lord, if my lord looks at page number 12, the petitioner is, my lord, Naveen Poswal. He has been referred to as the director of the company, which is admittedly under liquidation. My lord, these are the findings. My lord, a longish notice has been issued.
Did you intimate the ROC that you are in liquidation? The company is in liquidation.
Look, we have indicated that as
then
well.
What happened?
Now, my lord, I have replied to the show cause notice on 5th March 2024 at page number 52, where my specific, my lord, stand has always been that I was never the director. I was an employee of the company, but I was never a director. No form DIR 102, DIR 12, my lord, has been signed by me. No consent form was ever signed by me.
Had the company not been in liquidation, even then you would not have been the director.
No, it has been my stand all along that I was never a director.
All right.
Even thereafter, my lord, notices have been issued in my name. Now, my lord will also kindly takes at page number 55. My lord will find the liquidation order.
Who are you in connection with this company?
I was an employee.
Employee?
Yes, my lord. But I have been referred to as a director where I have no knowledge that I was a director.
What do you do now?
My lord, I do business, your lordship. At present, my lord, I have a separate shop.
All right. Yes. Then,
My lord, I am no way, my lord, this is my stand, and that's why, my lord, what I have prayed, your lordship. If my lord kindly takes my prayer as well. At page number, my lord, 8. Only, my lord, to the extent to delete my name from these show cause notices that has been issued. Also, my lord, I have also issued a demand justice notice, your lordship, at page number 65 to the.
what is the stand of the official liquidator?
Lordship, first of all, we are not getting any record that the company has gone into liquidation. That is the first, my humble submission. And secondly, is the official liquidator in this particular matter is not the answering respondent because he is seeking.
No, is it in liquidation or not? This is what I want to.
We are not getting from
Where from you say that it is under liquidation?
Appended the order, man.
Bonding up also, nothing has been enclosed. That the company was
If
wound
my
up.
lord kindly takes page 55. This is the order of the NCLT, my lord. Page 55, order dated, my lord. Fine.
12th March 2020.
Yes, my lord. Page 61 is the, my lord, findings. Page 60, if my lord kindly takes. Paragraph 15. In view of the above facts, we hold the company such and such is required to be wound up by the tribunal, and hence the following orders are passed.
Lordship, in that effect, the official liquidator, maybe the resolution professional might have been appointed.
60 at the bottom, official liquidator attached to the Honorable High Court is appointed as the official liquidator for winding up the aforesaid company with direction to take possession of the assets. All direction upon the official liquidator.
We are not getting anything on record, my lord. If then I'm just praying for this 2 weeks time, I can again.
Please come. The petitioner's representation before the registrar of companies, seeking deletion of his name from the list of directors of Upohar Realcon Limited and Upohar Agro Industries Limited. 3 companies.
My lord,
it is the only one
company, your lordship. Page 55, my lord. Upohar Agro Industries Limited, your lordship.
Page 65, I can see 3 companies, names of 3 companies written, demand justice. Upohar Realcon, Agro, Solacia Constructions.
Maybe these are some other notices that have been issued in his favor as well, your lordship. I have to take instructions in this regard, your lordship.
Where is your letter in response to page 12?
My lord, page 52, your lordship.
52.
Upohar Agro Industries Limited, my lord. It's there.
This notice was given to you to respond within a particular period of time. You have not submitted the representation within 12 days.
My lord, I have
February
also indicated
24.
that due to some family reasons, your lordship, I have also indicated that page number 54 that why the delay was there, my lord.
আচ্ছা কি বললাম? Upohar Agro Industries Limited. Stop করুন. A show cause notice was issued to the petitioner on 15th February 2024, and the petitioner was directed to reply within 12 days from the date of the letter. Stop. The petitioner has replied, however, at a belated point of time. Stop. The said representation of the petitioner ওখানে ডে শো কজ নোটিস কবে বললাম 15 February, followed by a for the notice dated 20th February 2024. Yes, from the date of notice of the letter. বললাম তো। From the replied on is pending consideration till date. Paragraph none represents the registrar of companies. Stop. In the absence of the registrar of companies, comma, the court is not in a position to decide the issue conclusively. Stop. The specific stand of the petitioner is that he was never a director in the company. Stop. He was merely an employee. Stop. The subject company has gone into liquidation. Stop. Paragraph. Without entering into the merits of the matter at this stage, the instant writ petition is disposed of by directing the registrar of companies to consider and decide the subject issue in accordance with law at the earliest, but positively within a period of 4 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to the petitioner immediately thereafter. Stop. আচ্ছা ডেপুটি রেজিস্ট্রার করুন। আর if any opportunity of hearing is required to be given, comma, the same shall be provided to the petitioner. You have not implemented the deputy as a party. The notices were issued by the deputy registrar of companies. What's going to happen? যেখানে বললাম না যে ডেপুটি রেজিস্ট্রার, ওখানে আপনি বলুন the registrar of companies consider it through the deputy registrar. Service taken on record. Call the passover matters. Yes.
Now, my lord, grievance of the petitioner is, my lord, Employee State Insurance Corporation, my lord. Initially, my lord, made an inquiry and, my lord, found me, my lord, I am liable to pay a sum of rupees 1 lakh.
On account of?
On account of, my lord, non-payment of, my lord, employees insurance fund. Now, my lord, to that, my lord, we have paid after adjudication. Now, my lord, after that, my lord, while calculating the interest, my lord, I was not put on notice, my lord, an order was directly served upon me, my lord, that is at page 26. And I was not given a hearing at all. Prior to that, I'm giving a hearing, my lord, I have paid that amount. There is no dispute to that. But this is only in account of interest that is under section 39(5). My lord will find.
Yes,
39,884.
And 39(5). ঠিক আছে. Yes.
Now, my lord, second of all, my lord, after passing this order, my lord, without giving me a hearing, my lord, a certificate proceeding has also been initiated at page 29 without calling me. Now, my lord, turns over, my lord, page 30. My lord, this is again, my lord, an order, my lord, for damages. Now, my lord, here, my lord, they put me on notice, but the notice which they put me on, my lord, I informed them, my lord, at page, kindly turns to page 31, my lord. I say that you called me on hearing on 7th December 2023, but I received the notice on 23rd of December 2023. So
23rd?
23rd. Now, kindly sees.
The letter is dated 23rd of November and the date of hearing is 7th of...
Oh, previous letter. 23rd November.
23rd November and 7th December is the date of hearing. Yes.
I received it on, my lord, kindly turns to next page. I informed them that I received it on 23rd December 2023. And they pass an order for damages on 8th of December. That is, my lord, the next page. And this was received by them. So, my lord,
Today, my lord, I am only saying, my lord, the basic, my lord, which is under the statute itself, my lord, prior to passing any order under the act, I should be given an hearing,
Any order?
any order.
Let me see.
একটা বই নিয়ে তোর বইটা কোথায় গেল? হ্যাঁ, affidavit of service টা দিয়েছিস sir?
But this order is an appealable one, isn't it?
No, if there is infraction of statute, my lord, it is maintainable on, my lord, Willful's case, my lord, violation of natural justice. And, my lord, infraction of statutes. My lord, kindly takes up my lord, 45A, my lord, the first proviso. My lord, got the first proviso, provided that no such order shall be passed by the corporation unless principal or the immediate employer or the person in charge of factory or establishment has given a reasonable opportunity of being heard. So, my lord, first order, my lord, yes, they have given me an hearing. My lord, I have participated. After adjudication, I have paid. My lord, I am not disputing that. And, my lord, 85 chilo, na? And, my lord, 85B is another provision on damages, my lord, which says the first proviso to 85B also, my lord, permits me, my lord, an opportunity of hearing.
Forty-five A is
Yes.
in relation to section 44
Yes,
or 45(2),
yes.
right?
Huh.
Here, this order is being passed under section 39
and 40. My lord, this 45 social security
40.
officers in their functions includes, my lord, imposing of, my lord, damages, interest, and, my lord, recovery of the amount which I have not paid on account of ESI. Now, my lord,
And the rate of interest is also specified.
it is a simple rate of interest not exceeding the scheduled rate of bank.
Right.
Now, my lord, in interest case, my lord, there are umpty number of judgments where I can say if I'm prevented by sufficient cause beyond reasonable my control, I can seek for waiver of the interest. So, my lord,
Here, where is the provision for waiver?
my lord, these are decided by judgment. If my lord says,
Not
my lord, I can plead.
judgments. From the act, you have to show
Yes.
that there is a scope for waiver,
My lord,
because this is a welfare legislation.
yes, yes, absolutely.
So waiver in the Employee State Insurance Act,
Yes.
especially under this provision,
Yes.
where the interest also has been specified.
Yes.
You cannot direct payment of anything less than 12%. Higher rate may be quantified later on, but the minimum rate is 12%.
Yes.
What is the rate of interest that has been charged in respect of you?
But that is page.
Still 15 minutes or 10 minutes left. Thereafter, you can continue with your conversation. Yes.
My lord, they do not state the what rate.
You can calculate and find it out.
Yes, that I can do. But it says it's under 39(5).
Right. 39(5), there is no provision for granting you any opportunity of hearing, because the initial, at the initial point of time, you were heard. Now it is the interest in terms of the act.
Even in
What is
interest,
to be heard?
even in interest, my lord, this court has, my lord, passed several decisions where, my lord, it says if the statute says why opportunity, to show before the authority that why I was not able to pay within that time. So, my lord, I can say today, my lord, kindly waive the interest.
Show me from the act.
My lord, if my lord give it a rules আছে এই বইটা rules, if I can take the rules.
Yes, please. What will be the submission of the state?
And my lord, 85B is specific.
Corporation perhaps
Somebody will be appearing, should have been appearing for the corporation itself.
Yes.
That
Who appears? Employee State Insurance Corporation?
ওদের কি serve করা হয়েছিল?
সবাইকে serve করেছে, all private,
Corporation has also been served.
all parties have been served.
Inquire, you also come back.
Very good.
Please come. The petitioner is aggrieved by the ex parte imposition of interest
And damages, my lord, both.
and damages.
Damages to the extent I received the notice letter.
Whatever.
Corporation case.
Stop. None represents the Employee State Insurance Corporation. Stop. Let a further notice be issued.
Yes.
Released on
Notice, should the notice.
15th of July. Affidavit of service is taken on record.
Okay.
Call the next possible matter.
14, my lord, I beg to appear for the respondent Life Insurance Corporation of India.
I appear for Union of India.
All right. Yes.
My lord, it's a case, my lord. Well, the gentleman, my lord, died, leaving behind by the legal heirs of first wife, and my lord, leaving behind the legal heir of second wife. The insurance policy which was lying with the LIC, my lord, maybe there are nomination and all these things. Our humble submission before the LIC authority that the nominee is the mere custodian of that particular amount, that amount to be distributed among the legal heir. We wrote them on several occasions, but I think, my lord, the LIC authority, my lord, fails to, my lord, realize the representation made by us, because of mere custodian may not be, my lord, the permitted to, my lord, usurp the whole amount which was lying there.
Has your representation been considered?
Not considered.
My lord, there is a point of maintainability, my lord. First of all, LIC has not been made a party. Other than that, my lord, perhaps this writ petition itself is not maintainable because of the sole fact that the claim has been settled in favor of respondent number 4, the nominee, the second wife. Now, my lord, by virtue of section 39 of the Insurance Act, subject to correction by my lord, paying the money to a nominee is a valid discharge for an indemnifier, which has already been done, my lord. Now, once the payment has been done, my lord.
When was it made?
My lord, may I hand over a copy of the instruction, my lord, that I have just received?
LIC, we have made party. They are implemented party.
Where?
Respondent 3. The manager.
Is the manager and the Life Insurance Corporation the same thing?
The
What
parent
to?
organization not made party, but
Then?
the manager has been made party.
My lord, kindly takes up the correct to them.
Even then also, my lord, my prayer before this, my lord, honorable court, the nominee should distribute this amount.
Then go before the civil court and obtain an order. Why the Life Insurance Corporation can do nothing?
At the same time, my lord, it is their duty to communicate us in an appropriate term, that being the law, and you should go there and take your share.
LIC will become your advisor now.
No communication, nothing of this sort, my lord.
Please
We are
come.
writing this letter, my lord. We
The petitioner
for a judgment.
claims to be a nominee. Is a private respondent there? What is the submission?
Yes.
Submission is told, but there is a family settlement in prior to the by the father of the petitioner.
Very well. The petitioner কি বললাম? Nominee of. No, the petitioner claims to be an heir and legal representative of
My lord, the
a person who had obtained a life insurance policy by naming certain nominees. Life insurance policy by naming certain nominees. Stuff. The petitioner submits that the nominee does not have the right to usurp the entire money in the policy, and the nominee is bound to share the amount with the heirs of the deceased policy holder.
Only paragraph 18 of Supreme Court judgment may kindly be mentioned.
Next. The petitioner relies upon certain decisions of the Honorable Supreme Court in this regard.
680.
Next, learned advocate representing the private respondent submits upon instruction that the money has already been distributed in terms of the agreement Naki, not agreement, family settlement entered into by the policy holder. Stop. Learned advocate representing the life insurance corporation submits that after the claim has been settled, comma, there is no scope on the part of the corporation to issue any direction upon the nominees to distribute the amount in favor of any of the legal heirs. Stop. Paragraph. Upon hearing the parties, it appears that an objection filed by the petitioner is pending consideration at the end of the authority. Stop. The authority ought to intimate the petitioner that the claim has been settled and the person in whose favor the same has been settled. Stop. The life insurance corporation, even after receipt of the representation of the petitioner, comma, did not make any further communication. Stop. Next. In view of the above, the instant writ petition is disposed of by directing the competent authority of the life insurance corporation to intimate the petitioner the fact of settlement of the policy and that the same has been closed, so that the petitioner may take subsequent legal steps for redressal of their grievances.
My lord, may I humbly
is a judgment
receive-
para
My lord,
18.
there is an annexure, my lord. It seems it's a communication from LIC, but this is the
What is
condition
written
of this annexure, my lord. I'm in no
Page.
position. My lord, this is the second last page of the annexure, my lord. I'm in no position to ascertain whether it has been communicated by LIC, my lord. This is the state of the annexure, my lord.
My lord,
Only the letterhead is
Well,
visible, my lord.
let me see.
unless and until we
Is
get
it
any
page
order from the Honorable High
24?
Court,
My lord,
issue.
I believe,
Written.
my lord, the pagination is also not visible, my lord. I'm very sorry, but which is why I reserved my submissions on this annex.
Page 23, my lord.
23 item.
23.
Legal
In
notice
this
to
respect, we would like to
unless
submit that
I get
until
any
and unless
order.
we get any order from the Honorable
There
Court,
is a communication.
office will proceed.
No, it's regarding the stop payment claim.
Yes.
With the fact that it has already been settled and closed, intimate, they can take it up.
Very well, my lord.
Lord, may I hand over the judgment, my lord?
No,
Judge,
disposed.
Honorable Court referred it.
Reference টা দিয়ে দেবেন তো।
Paragraph 18.
My lord,
Whatever.
kindly, much
Yes.
obliged.
আরো আছে?
Item number 18.
Deeply
Yes. 18.
I have served, my lord.
Russia IPF to the Reserve Bank of India.
Reserve Bank.
Yes.
Lord, this is really challenging, my lord. The willful defaulter, my lord, show cause notice issued by Bank of India. No, affidavit of service. Bank of India. Yes.
Yes.
My lord, show cause notice, my lord, has been issued completely based on a forensic audit report. Just copy pasted the forensic audit report, my lord. That I have challenged. Now, also, my lord, subsequently, they say that they have declared me a willful defaulter, but my lord, the order was not communicated. Only a letter has been given to me saying you go before the review committee. My lord, twofold submission. First, my lord, the show cause notice itself is bad because it's premised on a forensic audit report, my lord, which is inconclusive. I have judgments, my lord, to support that. Point number 2, my lord, is that the order was never communicated to me. And the
Order of the identification committee.
order of the identity.
It was never communicated.
It's a letter, my lord, I will show. But
Okay.
also, my lord, if the initial action, my lord, itself is bad, my lord, the foundation.
Where is the order of communication which you
Yes, the
place?
show cause notice, my lord, is at page 65. I'll just show quickly, my lord, this. Kindly comes to, my lord, page 65. Show cause notice. And page 66, my lord, are the allegations. Kindly seize, my lord, paragraph 5. By virtue of the RBI circular, bank is empowered to institute willful default proceeding. Justification based on major findings of the forensic audit report dated such and such are below. Now, these are, my lord, 1, 2, 3, 4, 5, completely, my lord, picked from the FAR and pasted here. And now, my lord, the FAR, my lord, had some disclaimers, which I have not annexed the entire report. Page 68 and
Where is the communication? Please show me.
yes, communication,
Identification.
my lord, is at page 87.
Yes.
Page 87, they say this is the order of the identification committee. Kindly see, my lord, who has signed this at the bottom, my lord. For and on behalf of willful defaulter. The committee
No,
is
for
there.
and behalf of the identification committee.
Yes, but the order has to come. Kindly see, it is a notice. We refer to our show cause notice dated such and such in terms of the RBI guidelines. On receipt of the notice, in response, bank received written representation. You have also requested for personal hearing. Again, scheduled personal hearing such and such. Next, on the basis of the facts on record, identification committee headed by the executive director and comprising of 2 general managers accepted the recommendation and declared you willful defaulter on 18 March 2024. So, my lord, if at all, that is the order, leaving aside, my lord, everything else. VDA memorandum dated 11 March 2024. In the capacity of promoter director, this declaration is subject to further confirmation by the review committee.
1 minute. Where is the communication of this order upon the petitioner?
Your Lordship, firstly, we had given them a chance of personal hearing on 2 occasions wherein they did not appear. Your Lordship, upon instruction, all the due compliances have been made. Your Lordship, kindly allows me.
Show me the communication of the order of the identification committee upon the petitioner.
Kindly allows me some time to file my affidavit in opposition. I shall bring on record all the compliances made in this matter, Your Lordship.
Please come.
Very well. In that case, may I also say one thing?
Petitioner is
I have
aggrieved by
received
the act on the part of the Bank of India in allegedly not communicating the order of the identification committee declaring the petitioner as willful defaulter. Stop. It is also the submission of the petitioner that the show cause notice is bad as the as portions of the forensic audit report has merely been pasted in the said order. Stop. Was the FAR given to you?
No, not a copy was also.
Copy of the forensic audit report was also not forwarded to the petitioner. Paragraph. Learned advocate representing the Bank of India denies the allegations of the petitioner. Stop. It has been submitted that all compliances were made for declaring the petitioner as willful defaulter. Stop. Paragraph. The Bank of India is directed to file a report by way of affidavit disclosing all documents in support of declaration of the petitioner as willful defaulter. Stop. The forwarding of the forensic audit report and the order of the identification committee shall be annexed to the affidavit to be filed by the bank.
Your Lordship,
by 18th.
Your Lordship, they are saying that the forensic audit report has not been given to them. However, on page 9, Your Lordship, last line, they have craved leave to refer upon the same at the time of hearing.
They have not issued it.
You show that you forwarded, right?
We shall, Your Lordship.
By
Kindly grants 3 weeks time, Your Lordship.
3 weeks?
Yes, Your Lordship.
At the 25th of July. Release the matter on 11th August.
Ready.
Exception to the affidavit may be filed by the petitioner prior to the adjourned date.
Right, if it so commences, Miller, the review committee has already now taken ceasing of the matter and is issuing me an order. So
why don't you approach before the review committee and get everything resolved? Because identification committee's order is not a final order. It has to be approved by the
order already. That has
then your cause of action over here doesn't survive any further.
They have given a notification to me. So I want, Milord, I'm asking, Milord, if there can be a stay of further action.
It is not before the court. Review committee's order,
Well, then,
steps
Milord,
taken.
This will not be heard.
But then you bring everything on record so that the review committee's decision and steps taken by the review committee also, you please bring it on record.
I shall, Your Lordship.
This is my application.
Yes.
My lord, senior citizen, son and daughter-in-law. Now, my lord, during pendency of this case, some development was happened where my lord son took away his wife to another alternative place. And my lord, though my lord a strained relationship is there, my lord, page 131, my lord, kindly come.
No, but then right now there is no grievance.
Right of now, my lord, I am living there peacefully. We are living there peacefully.
I'll
My lord,
dispose
page
it off.
Why, my lord? Page 131 is my application before the maintenance tribunal, the SDO. My lord, only direction, if they are taking the instantly, I would not have come before your lordship.
No, but then
My lord,
the tribunal will definitely take
there is
steps.
no such grievances. My lord.
The
Grievance-
wife left out the house, my lord,
My lord,
with the
keep
son.
that liberty if there is anything, then my lord.
Liberty is not required, otherwise the relationship will become further straight.
My lord.
As your lord, as your lord.
আচ্ছা লিখুন তো। It appears from the
No, no,
submissions made on behalf of the are you there for the private respondent?
Yes, yes.
No, no, my lord.
For the state with.
Oh.
তুমি private
And-
respondent?
No, no.
আমি ভেবেছি তুমি private, but private respondent,
Upon hearing the submission made on behalf of the petitioners, it appears that at present the grievance of the petitioner under the provisions of the welfare of
no, no.
the maintenance and welfare of Parents and Senior Citizens Act is currently taken care of stuff. The son of the petitioner has shifted his wife to a different accommodation, and the petitioners are presently residing at peace. Stuff paragraph. The instant writ petition is disposed of by merely observing that the inspector in charge, Uttapara Police Station, shall keep strict vigil in the
Already
area
there, my lord.
to ensure that
Already.
there is no breach of peace in the locale and the senior citizens may live in their house peacefully without any interference from any other family members.
I'm grateful.
Disposed.
Difficulty is, my lord, of the son, my lord.
May I get a
Which side he would take, my lord, it is too difficult.
Sandwiched.
My lord, sandwiched. Exactly,
doctor?
lordship.
May I get a report
Is-
of this?
Give a copy. আমাদের একটা রেকর্ড রেখে দিন রিপোর্টটার।
I'm grateful.